May I please allow? Well, I want to withdraw the petition. Later, but we come for listing tomorrow, madam.
So it's there for listing, give it to the court master.
May I please allow? I make the mention for listing. You should not.
Give it to the court master. Not there for listing.
May I please? Into expedition, we are the highest.
Please give all the pairs for listing to the court master.
Agency, there are two more lots.
Still give it to him.
Daily list item number 1 for admission.
Yes, please, Your Lordship.
Yes,
This matter may be taken after some time.
after some time. Okay. It is only for that last point, whether post benefit you can be, post retirement you can be given that benefit.
Oh, yes, my lord. Yeah, 20.
2 to 5.
Yes,
Otherwise, my lord, I have concluded, my lord, subject to.
reply.
Reply.
I'm sorry.
My lord, I'm sorry, my lord, one urgent matter, can you please for tomorrow, man?
Give to the court master, please.
My lord, in these matters, I have placed the.
Just a moment. My notes are securely stitched.
Okay.
Yes,
I have only placed the definition of forest produce as well as mineral. My lord, so far, forest is concerned, it must come from forest, then only, my lord, these stone and other things are forest produce, otherwise it is mineral. Now, in these cases, my lord, because I have placed the first case only, text, if your lordship see, these are all minerals. Your lordship will see first 5052, 2-3 elections again, I shall place.
5052. Yes. Just give me 1 minute more. I've still not been able to
My lord,
take out my notes.
yes, sure.
बहुत दिन हमारे दिसे. Yes, today is the day of conspiracy against me. Mr. Saiwala, then I see Mr. Pathak, then I see Mr. Mishra. Mr. Mishra, I was just in a lighter vein addressing the house that maybe it's a day of conspiracy against me.
Just
Mr.
now I was
Saiwala,
telling
then
him,
Mr. Pathak, then you.
just now I was telling him, my so many good days were there, assisting my learned colleague those days. And that he was having a kind of magnanimity which I have not come across.
You know, those days, there was one more good thing. That the honorable judges had the patience of hearing. Now we have lost that.
So my little advocates of a person like him, we used to learn a lot.
No, that is true. But that is the flip side now.
No, the
There is change of
volume,
times.
the volume of the work is increasing. The workload is increasing. Because of that, we can't say anything else.
Mr. Nahar will evict you.
Yes.
We will evict you.
Now another person.
No, no. Because Mr. Mishra was sitting here, so we are evicting him for the.
He always points his finger at you.
Yes,
My lord.
I'm sorry. Yeah,
My lord,
some
this
distraction.
this next, my lord. 5052, my lord, if you also see, page 51, annex 6 series.
Page
51,
51.
annex 6 series 51 to 54. Now,
Yes.
these are the transit passes issued while removing the materials from the mines. Because as per the rules, my lord, they have to issue the transit pass. And these transit passes were issued by Department of Environment and Forest.
Yes,
The consignor, my lord, this minor mineral concession area holder, Mohaldar contractor, the name is there. Now, if you also see the second column, type of mineral stone given. So it is not as a forest produce, it's a mineral, my lord. All these transit passes are for minerals. So the question of argument, my lord, that stone may be forest produce, my lord, so that question does not arise so far this case is concerned. My lord, these are there up to 56. All the, my lord, the transit passes are there up to 56.
yes,
My lord. And similarly, my lord, the impugned penalty tickets were issued at page 66 onward. These are also for minor mineral. Page 66, 67 both. These are for minor. And in the affidavit also, my lord, they have said it is a minor mineral. And they have taken action as per the MG rules 2013. My lord, may come to para 7, my lord, their affidavit, page 4.
paragraph.
Paragraph 7, my lord, 8, paragraph 8, my lord. Page 5.
Yes,
The deponent understands that penalty tickets were issued against minerals found to be without requisite papers. Such penalty tickets were raised online for compounding offences as mandated under MC rules. More particularly, is Rule 64 of the MC rule. Vehicles can be released after realization of payments and such. So there is no dispute that The materials involved in this case are minor minerals. My lord, this is a list of minor minerals, my lord, issued by the central government. Nowadays, my lord, now they are adding more and more. In 21 amendment and 23 amendment, my lord, they are doing more, my lord, for private, my lord, even gold and other things are also being. 23 amendment is there. So they are becoming more liberal, my lord, in granting concessions to the private.
Yes.
Now, already I have placed, my lord, he has also placed section 3(4)(b) of the first regulation, my lord. The following when found in brought from a forest, that is to say. So that is, my lord, it must come from forest. And that Kumar case also has also said, my lord. I have placed that, my lord. I am not repeating it. Kumar case has said not brought from, but it must be brought from forest. Then only it will be first. My lord. Your losses, that again, my lord. Moreover, my lord, under Forest Act, my lord, section 40, my land has based that they can make rules for transit of forest produce also. But in minor minerals, my lord, that is not so, that I missed. My lord, this has been considered in the Kumar case, my lord, that is 1814 SCC 537, paragraph 119, my lord. Two thousand 1814 SCC 537. It's 590. 590.
Page 119.
My lord,
Page 119.
119.
Para 119.
Para 119. That para 117 also your losses may see, my lord. that that Forest Act, Central Forest Act is. Meaning of the words brought from as used in section 2 clause 4b become very significant in the present case, since the case large number of listeners that those which are transiting did not originate from any forest area, rather they have taken from non-forest area, hence there is no liability to pay the transit fee. Whether forest produced is defined as so and so should be forest produced which originated from forest, or even the forest produce which is merely passing through a forest area shall attract liability transit fee. Question is to be answered. Well, that has been answered in matter 109 matter. The word from is used to denote the point of time, a place, or a period. Both the words found in or brought from have been used before the word forest. Both the words that is found in and brought from have clear nexus with forest. The true meaning of the words brought from or has to be appreciated when read in the context of the words found in. The words brought from is the expression which conveys the idea of items having their origin in the forest and they have been taken from the forest. The word from refers to the place from which the goods have been moved out, that is, from the place of their original location. The forest is a birthplace and the origin of the items mentioned in paras so and so, so and so. The word found in mean the item which has origin from the forest is found in forest, while brought from means items having origin in the forest have been moved out. 1978 rules under 4127 Act reflect rulemaking authority also understood the meaning of the words brought from in the above sense. As per Rule 3, no forest produce shall be moved to or from or within the state of UP except without a transit pass so and so. Well, I'm not stressing much, my lord. Then in the next 122 also, my lord, details 122, 23, my lord, these are details, my lord, they have considered. Then lastly, in 215, my lord, that is the conclusion, my lord.
Yes.
Conclusion 215, para 215.3, my lord. Because after discussion, many things are there, my lord, I have only placed those, I'm not placing. 215.3 at page 627.
Yes.
The words brought from as occurring in 24B of the 1927 Act mean that from forest where from forest produce has originated. The words brought from forest cannot be read in brought from forest. We however clarify that for the item to be treated as forest produce, its origin may be in the forest, any forest within the state of UP or the forest outside the state of UP. So brought through forest, my lord, it may materials may be brought through forest. That does not mean that it will be a forest produce. So here, my lord, the question of forest produce does not arise at all, my lord, because the items are minor minerals. As a mineral, my lord, these were transit passes were issued from the transferring the mine mineral from the mines, and thereafter, my lord, the petitioner purchased it. Minor mineral. Now, my lord, section 15 of the mineral mines and minerals Development Act. My lord, my learned friend, are too much for that, my lord.
Yes.
State government may by notification the official gazette make rule for regulating grant of quarry lease, mining lease, other minerals concession in respect to minor minerals and for purposes connected there. My learned friend has, my lord, given more for the purposes carried. Well, I say, my lord, it is use of plenaries. It means the previous words, my lord, not otherwise, because I have already placed the Gujarat case, my lord. Gujarat case has clarified, my lord. So, lordships, remember, my lord, I shall place 2-3 paragraphs again, my lord. So for Gujarat case is concerned, it has clarified it. What the meaning of the purpose is connected there. Two 2019-16 SCC 513, my lord, that I have.
Which case?
Gujarat case, my lord, that is just by 2019-16 SCC 513.
2019?
16 SCC 513. I placed in detail that word, my lord. That.
Yes.
My lord, here, my lord, if your losses comes to paragraph 35, my lord. Paragraph 35.
Yes.
The appellants have submitted that section 15 gives such a power, subsection 1, section 15 empowers the state government to make rules for regulating grant of quarry leases, mining leases, and other concessions in respect of minor minerals and the further purposes connected therewith. This power of regulation pertains to granting of leases. It is the submission of Mr. Kapoor that expression regulating is of widest amplitude and would therefore confer power to make rules of the nature made herein. There are also rules they have challenged. He has referred to various judgments of the court wherein expression regulating has been explained. He has also submitted that in any case, under section 15(1)(a), such power is there and this provision has been read independent of section 15(1). It is difficult to accept the aforesaid contention in view of the judgments of this court in MPP Kaveri Sethi and KT Bhargij. In those judgments, it has been categorically held that power of the state government under section 15 of the MMDR Act does not include control of her minor minerals after they are excavated. The following observations from the said judgments are extracted below. The High Court quashed Rule 8D and 19B principle on the ground that section 15 of the said Act gave no power to state government to frame rules to regulate the internal or foreign trade in granite after it has been queried. Section 15 also did not empower the state government to frame rules to enable a state government to government company or corporation to fix minimum price of granite. The Learned Counsel for the appellant submitted that Rule 8D and 19B were valid having regard to the preamble of the said Act and section 18 thereof. He submitted the rulemaking power of the state under section 15 is wide enough to encompass 8B and 19B. The said Act is enacted to provide regulation of mines and development of minerals under the control of the Union. Section 2 of the said Act declares that the expedient in the public interest that the Union should take under its control the regulation of mines and development of minerals to the extent provided in the said Act. Section 13 empowers the central government to make rules for regulating grant of prospecting licenses and mineral leases in respect of mineral and for the purposes connected therewith. Subsection 1 of section 15 empowers the state government to make rules for regulating grant of quarry leases, mining leases, and other mineral concessions in respect of minor minerals and the further purposes connected therewith. Subsection 1A of section 15 provides that such rules may provide for matters set out therein, namely the person by whom and the manner in which an application for quarry lease, mining lease, and the like may be made, fee paid to so and so, so and so. Well, I'm skipping over this. Now your losses come to last 3 sentences, 4 sentences. Clause O of subsection 1 reads any other matter which is may be prescribed. Section 18 of the said Act states that it shall be a duty of the central government to take all such steps as may be necessary for conservation and systematic development of the environment, preventing, controlling pollution caused by so and so. Rules 8D and 19B empower the state government officers of the state company or corporation of the state government may direct to control the sale by every permit holder of the quarried granite or other rock suitable for ornamental or decorative purposes. They also empower the state government or its officers of the state government company corporation as the case may be fix the minimum price of the sale thereof. The object is to show the terms of the government order number so and so quoted above is to conserve and protect granite resources. It is difficult to see how the granite resources can be protected by controlling the same sale of granite after its excavation and fixing minimum price thereof. There is no power conferred upon the state government under said act to exercise control over minor mineral after they have been excavated. The power of the state government as the subordinate rulemaking authority is restricted in the manner set out in section 15. The power to control sale and sell price of the minor mineral is not covered by the terms clause O or subsection 1A of section 15. The clause can relate only to regulation of grant of quarry and mining leases under minor mineral concessions. It does not confer the power to regulate sell already mined mineral. Likewise, the conditional license granted by the state of Kerala, well, similarly, by the same thing. So this is what, my lord, I am submitting that those things, my lord, the three words, my lord, in section 15 does not give power, my lord, to regulate the transit of the minor minerals once it is excavated and transferred from mine area. My lord. And scope of section 23.
But Mr. Saiwala,
Yes.
the hard reality is, like we have seen in the coal which is coming from Meghalaya, coal which is coming from Arunachal.
Yes.
You see, I have dealt with it in judicial side. That's why I am aware of it.
My lord.
In Arunachal,
Yes.
about 2,500 metric tons of coal. There was a report that it was washed in rain. And till today, after about 3 years, we are still finding challans coming from Arunachal Pradesh, showing that they are coal originating there.
My lord.
Meghalaya coals,
Yes.
the coal mining has been stopped at what point of time we don't know. But still there is transit passes and challans coming from state of Meghalaya for transportation of coal. Therefore, if we accept this, with all respect to this Kaveri Chetty, if we accept this, that after mining, the state has no control.
No,
Then how do
yes,
we-
yes, my lord, it is there. Section 23C. 23C, my lord, that is why I am coming, my lord. If you also see para 40, 41. Para 40 onwards.
Yes.
Para 41, my lord. In so far as section 23C of the MEMD Act is concerned, it was inserted by 1990 Amendment Act with the objective to prevent illegal mining. My lord, this. That is clearly spelled out in the statement object reasons. We may report itself there. So a new provision proposed to be inserted act prohibiting transportation or storage or anything causing transportation or storage of any mineral except after due provisions of the act with a view to preventing illegal mining. Further, the act is proposed to be amended to cover the breach of the provisions of the proposed new provision of the act to be punishable. It is also proposed to insert a new provision to provide anything seized under the act as liable for confiscation under court orders. A new section is proposed to be inserted to empower the state government to make rules for preventing illegal mining, transportation, storage of mineral, and the further purposes connected therewith. It is in this context the words transportation and storage in section 23C are to interpret it. Here the two words are used in the context of illegal mining. It is clear that it is a transportation and storage of illegal mining and not the mining of minor minerals like sand, which is legal and backed by duly granted license, which can be regulated under this provision. Therefore, no power flows from this provision to make the rules for regulating transportation of legally excavated mineral. As far as issue B is concerned, we are also considered opinion that impugn rules violate part 13 of the Constitution as the effect thereof. To fetter the freedom of trade, commerce, intercourse under Article 301 of the Constitution. Under this article, the expression freedom must be read with expression throughout the territory of India. Under Article 302, Parliament may impose restriction on the freedom of trade, commerce, or intercourse between one state and another as may be required in public interest. The expression public interest may include a regional interest as well. However, Article 302 is qualified by Article 303, which prohibits Parliament and the state legislature from making any law giving preference to one state over the another or discrimination between one state or another. Situations of scarcity are to be dealt with by the Parliament under Article 302(2). The power of the state legislature to impose reasonable restriction on the freedom of trade, commerce, or intercourse as may be required by public interest requires such a bill or amendment to be moved in the state legislature only after receiving the previous sanction of the president. My lord, this is it, my lord. So, my lord, that is why the rules have been framed, my lord, that I have already placed before your lordship, my lord, that the rules of 2021, 2020, my lord. That rule, my lord, is exhaustive rules. If your lordship-
You see, this judgment of Gujarat
Yes,
was passed in the context.
yes,
If you will come to para 2,
my lord.
they were prohibited from transporting the legally excavated sand,
Yes,
stone, etc.
yes,
to any place outside the state of Gujarat.
my lord. Whether inside or outside, my lord, that is not a question, my lord. The question
No,
is.
the question will come because you
Yes.
see, that is the reason, and therefore the Supreme Court is interpreting,
Ah.
saying that by invoking 23
Yes,
C, you can't prohibit the interstate trade and commerce.
Ah. Yes.
Because interstate trade and commerce is under the different chapter in the Constitution of India.
my lord.
Now, therefore, you see, here what is happening is a parallel, what you call transportation of goods, which the government suspects that it is not legally mined.
Correct.
So therefore, this is not a 23C, the notification which you have shown under MMDR Act
Yes.
on the last occasion. That must be read in the context of the illegal transportation, not in the context of the Gujarat High Court judgment, where it is the prohibition in interstate trade and commerce.
My lord, this is not
And
only
the
interested.
state government's argument
Yes,
is to the effect that under the Forest Act, it was a pre-existing act and it contains provisions for regulating the trade of
first produce.
forest produce. And therefore, once the definition is that even stone is a forest produce, so therefore they are regulating it by that notification and issued by the state government.
My lord, my humble submission is this. If it's a forest produce, then only they can my lord regulate. This is not a forest produce, this is a minor mineral. And that is why, my lord, this 2020 rules is framed, and this rule is exhaustive. If I place, my lord, the rule, that's the exhaustive how, my lord, a person can store, can sell, everything is there. My lord, if your office may take up, my lord, 2020 rules. Last time I have given,
I've seen that.
my lord,
I had seen that.
yes, that rule is very exhaustive, my lord. I mean, in this book, my lord, if your lordship.
Yes, this one.
Yes.
Hmm.
My lord, if the losses comes, my lord, to rule 4, we have to first thing a dealer has to register itself.
Yes.
My lord, they have to deposit, my lord, fee of 20,000 and other things are copy of PAN, registration certificate, GST registration, everything has to be given for the purpose of registration. Then the process of registration is there. Then Rule 6, that is important, my lord. No person shall transport, otherwise remove or carry away any mineral from any place without obtaining e-way bills as per the standing instruction of the taxation department within the outside the state person.
Yes.
Now, rule 7, that is very important, my lord. The registration shall be granted in Form G subject to following condition. Dealer have to deposit, my lord, this is I am not explaining now. 2, dealer shall maintain correct and intelligible account of minerals procured, stored, stocked, processed, and dispatched from different locations. So processed also, my lord, because they can process it. The dealer shall submit copies of Form E to the Director of Geology Mining, Government of Assam quarterly. While removing the minerals from the stock or factories, the dealer shall obtain permission from the Director of Geology Mining, Government of Assam, and transport the mineral under the prescribed transport challan in Form D obtained from the Director of Geology Mining, Government of Assam. Then 5, the dealer shall maintain daily stock and transport registered in Form M and submit monthly return in Form H to the Director of Geology Mining, Government of Assam. Everything is there, my lord. Dealer shall allow any competent officer to inspect the stores and factories to verify the stock of minerals and take samples or extract from the records maintained by him. Every dealer shall allow a competent officer or any government officer authorized by the Director of Geology Mining, Government of Assam, or Secretary Mines and Mineral Department to enter into inspect premises where the furnishing of information as directed by the writing shall be obligated by Forsa dealer. The competent officer or the officer authorized by the appropriate authority in their behalf shall be competent to search any place in which there is reason to believe that an offense is committed and seize any stock or minerals in respect of which offense has been committed. The department shall be empowered to issue executive instruction as and when necessary for proper implementation of rules and regulating mineral matter. Then penalties are provided, my lord. Seizure confiscation there. Then so here, my lord, they have to obtain challenge from the, my lord, if you also will see, my lord, Form D. As per Rule 7, my lord, they can only transport goods, my lord, after obtaining the dealer's transport challan from the Department of Mines and Minerals. My lord, full proof, my lord, has been met in this matter, my lord. Because so Mines and Minerals, my lord, Section 23C has been completely, my lord, full given, my lord, the power to the search, seizure, penalty, everything, my lord, and confiscation, everything is there, my lord. So, if the minor mineral, my lord, this rule only apply. My lord, one thing my learned friend has submitted that in the definition of mineral in this, my lord, does not would explain, my lord, that if the losses come to, my lord, the definition of mineral here. Mineral means, my lord, section rule 2A, 1K. One argument has been advanced by my friend, my lord. Mineral means mineral of all types mentioned in the first and second schedule of Mines and Minerals Regulation Act, except atomic mineral, none of these. Now, my learned friend said that, my lord, from the list of, my lord, schedule A and B, if you also see, my lord, my learned friend escaped to show, my lord, that provision. Schedule, second schedule, if you also see in the Mines and Minerals Act.
It will be which page?
Schedule B is 34H. The new.
Yes.
That, my lord, the last item, my lord, 55 at page 34K. That includes everything, my lord. Because this is provided only the, my lord, royalty. All other minerals not mentioned here specified, so and so, etc. Everything, my lord, comes. It is not that, my lord, it is not included. One argument has been advanced by my lord. That so this is not correct. Everything. Well, forest department may not be given the power. So far, this rule is concerned. In the AMC rule, my lord, that forest department has been given for granting leases, permits, everything, my lord, whatever it may be. But so far, this is concerned, my lord, it has been given to Mines and Minerals Department. Take it as a- well, this is very-
Okay.
My lord, three types of, my lord, concessions can be granted under minor mineral rules. One is mining lease as per chapter 3. Yeah, another, my lord, chapter 4, mining contract. Third is mining or quarry permit, chapter 5. Three types of, my lord, concessions can be given under the minor mineral rules.
Please repeat again. What are the three types?
Chapter 3, my lord, it is mining lease, my lord. Chapter 3 is the mining lease. Chapter 4, mining contract. And chapter 5 is, my lord, mining or quarrying permit. This starts from, my lord, rule 8, 1823, my lord, in chapters. So three types of, my lord, concessions can be granted. And these, for these Y items, my lord, the forest department has been empowered to grant these three concessions. Except that, my lord, nothing has been given to the forest department. My lord, all power has been granted to the, my lord, mineral department. And the rule is exhaustive rule, my lord. My lord, my learned friend referred, my lord, that two judgments of the Supreme Court. One is Hindstone and another is Monet Ispat. My lord, that is saying that, my lord, they do not have a fundamental right to claim in the respect of mining. Well, these both the judgments deals with mining. Mining, my lord, my humble submission is this: so far mining is concerned, nobody has a fundamental right. Until unless he gets, my lord, mining lease, mining contract or permit, he cannot claim to be a fundamental right, my lord. He has to apply. Earlier, my lord, first come, first served basis. Now, my lord, central government has changed it. That's auction, my lord. They get more amount, my lord. So these two judgments, my lord, deals with only mining. Mining does not have any fundamental right, my lord, anybody. But so far, dealing in mineral, I have a fundamental right, my lord. I can deal with minerals, my lord. After mines, transfer from mines, my lord, with a valid, transit pass, I can deal with mineral. That I have a fundamental right now. Secondly, my lord, Lalkwa case and Kumon case, my lord, he has relied that after crushing, my lord, the materials remain the same, my lord. There is no dispute, my lord. I have also dealt with some cases for tax department, taxation, my lord. Materials, my lord, if it is a minor mineral, it remains minor mineral after crushing. If it is a my lord, porous produce, it remains porous produce. My lord. So that point, nothing to say, my lord. Thirdly, my lord, my learned friend has relied on two judgments, one Sakiri Bosu and another, my lord, Sakiri Bosu case, saying that for the purposes thereof. My lord, that I have already clarified, my lord, in the Gujarat case, 1916. Because that is just remedies, my lord. Previous words, my lord, it means. It does not give any further power to the government to claim anything. No, my lord, so far, this 2003, I shall have not placed the facts of the other three cases, my lord, I shall place shortly the facts of three other cases. Because second case, my lord, if you also see,
That is limestone.
no, limestone.
Limestone we are not taking up today. Because this, let me finish this, then I'll come to limestone, because they are two independent issues.
Limestone, my lord, that covers by the our division bench judgment, my lord. They have admitted that limestone is not under forest department. That they admitted, my lord, because I have already placed, my lord, the
This I'll list it again.
W. Ras, my lord.
This limestone I'll list it again, because
Yeah,
right now I'm
Anyway, my lord.
concentrating more on.
Anyway,
the-
now, my lord, I'm just pressing, my lord, this. Then I shall place, my lord, these two other cases. These are in respect of challenging the, my lord, section that 2003 notification. If your losses take up, my lord, 1357 of 2015 ABCI.
Because Mr. Saiwala, when there are two different aspects which are heard common,
My lord.
there are certain overlapping issues, because when I go home and then I'll start opening the file,
Anyway, my lord.
I would not be able to
No, anyway, my lord.
recapitulate that this argument
Yes.
was meant for what you call limestone, or it was meant for the
No, it's not
other
right.
forest produce.
Anyway, my lord.
Yeah.
I said, by any other day.
It was really very difficult.
Yes.
Two different issues,
My lord.
because when I'm in my study table, I have no assistance.
That is correct, my lord. Yes. That is the difficulty.
Yes,
My lord, in
1537.
1537. This is also a stone minor mineral, my lord, that we have taken, my lord. We have taken all the, my lord. We have challenged the section 3 notification here. Because, and if your lawsuit see, they are affidavit, my lord, in this case. Affidavit, page 5, para 10, my lord.
Affidavit by 1 and 2.
Yes, 1 and 2. Page 5, para 10. As regards apartment made in paragraph, you also document. Para 10.
Yes.
As regards abandonment made in paragraph 8 of the read petition, the deponent begs to state that stone crushing units use minor minerals, stone boulder and listed in Y schedule, MC rules, which are under the control of the forest department. Well, this is, this plea is absolutely not correct one. In this regard, the department has every right to regulate the functioning of the stone crusher unit as per the guidelines issued. However, the general manager DICC is also a member of the permit committee to examine whether the units are to follow the industrial norms or not. As regards the abandonments made in paragraph 9 of the read petition, the deponent begs to state that stone is a minor mineral and listed in Schedule Y under the AMC rules, and forest department has got every right to regulate its transportation. Therefore, the continuance of the guidelines is justified and transit challan as per guidelines is compulsory, carrying out crushed materials from the crusher unit. As the control of the stone and stone materials is within the forest department as it is enlisted in Schedule Y schedule, and therefore the stone crushing units are bound to follow the guidelines issued by the government. Permits are issued for getting consent from industry department, civil authority, and occupying so and so. So, my lord, there is no dispute, my lord, that these are the minor minerals. And this third case is also, my lord, Rakesh Singh, same case, my lord. But they are only, my lord, we are challenging the 2003 guidelines. Now, well, so far, the stone crusher units are concerned, my lord, whether it's a minor mineral or produced, my lord, forest department has already framed a rule, my lord. Pollution department. That is called Assam Stone Crusher Establishment and Regulation Rules. It is under, my lord, Prevention and Control of Pollution Act, air pollution. Well, just I am placing one of the, okay. That's the rule, my lord. Here, my lord, they don't say whether minor mineral or forest produce, my lord. They only regarding stone crusher. So the petition has taken the, my lord, permission from the pollution department. The judgment will be- Thank you, sir. I will be- That rule 4 says, my lord, they have to take NOC from the pollution control department.
Yes.
Normally, I shall place two judgments, my lord, of our High Court. Because they insisted for transit pass and transit challans, my lord, on date, my lord, we have present that. This is the 2009 3 GLR 586.
Yes.
My lord. Just your lordship to take it up. The first one. So, my lord, page 591, paragraph 13.
This 2009 3 GLR.
Yes,
Para.
2009. There are, my lord, the 13. 13 to 16.
Yes.
Let me examine the jurisdictional authority of the forest officer to insist for TP and transit challan in respect of stone entering or leaving the premises of the stone crusher. The regulatory power of the state government for issuing transit pass is manifest from section 40 of the regulation. As regards the regulation into transit of forest produce by land or water, there is no doubt about the existence of such power to regulate the transit and if forest vested with the state authority. The state authority having felt it's the necessity to regulate the transit of stone, treated stone crusher unit incorporated by such provisions as clause 17 of the aforesaid notification issuing guidelines for setting stone crusher unit, whereby the said stone crusher unit has been subjected for issuing necessary transit pass and transit challan. The aforesaid guidelines are not in the form of the rules as contemplated under section 40 of the regulation. Those guidelines have not been published in the official gazette, which is one of the requirement of the rule to make such provision applicable under section 72 of the regulation. Such executive instruction or direction clearly appears to be in various forms, such as circulars, memorandum, etc., and the legislature which are issued by the higher authority are directing the lower authority how discretionary powers are to be exercised. They also contain how internal matters are going to be governed and how rules are to be interpreted. They may also fill up the gaps in the legislation, including subordinate legislation. It is one of the principles of law that so long as such circulars or guidelines or memorandum are not contrary to rules or any provisions of law, it would remain as applicable. In the instant case, while holding that the stone is not a first produce within the meaning of the definition of as provided in the regulation, such power to regulate the transit of such stone, either in original or modified form, would not be subject to regulatory authority of the first official. Such regulatory, however, would be applicable to first produce only. In view of the aforesaid situation, Mr. Bora tried to salvage the situation by making assistance from Assam Minor Mineral Concession Rules and from section 15 of the Mines and Minerals Development Regulation 57. Referring to those provisions, it is contended that stone is also included in quarry leases, mining leases under the said rules, and designated forest officers have been declared as competent to issue lease on such mines or minerals. But it is noted that the scope of Mines and Minerals Development Regulation Act is entirely different. The said act was enacted to provide for development of mines and minerals under the control of the Union. The rules of frame provides as to how such lease of mines and minerals are granted. No doubt, the forest officials have been made as a competent authority, empowering them with the duties and responsibilities, the scope of and provision of the statute as well as Assam Forest Regulation. In exercising power under the forest regulation, the respondent authorities cannot be permitted to fill up the lacunae by borrowing some provisions from the Mines and Minerals Act in the absence of any such power under the regulation. The judicial authority to deal with mines and minerals may be with the higher officials, but that does not authorize them to do certain acts which are not empowered under the Assam Forest Regulation. Mr. Bora also refers to the undertaking given by the petitioners while they were granted license to set up the stone crushing units and submit that in view of the said undertaking, the petitioners have waived their right. By giving such undertaking, the petitioners agreed to abide by the provisions of law regarding installation of the stone crusher machine and referring to such undertaking, respondents authorities cannot be permitted to exercise power which are not contemplated under provision of law. In view of the above discussions, I find that prisoners have made out a case for interference against action or respondents requiring judicial review of the administrative action impugned in this batch of lead prisoner. Accordingly, the action or respondent authority demanding TP and transit challan in respect of stone processed classing unit of the petitioner extent quashed. Mr. Khatri, learned counsel for the they other given regarding authority of the present official demanding taking TP in respect of finished produce. In view of the above discussion, the land council does not finally place the vote. This is my lord, one of the cases, my lord, where partly, my lord, this point was there, my lord.
Yes.
My lord, so far the stone caster unit, my lord, they have also framed one rule, my lord, once under the minor mineral concession rule 1994. That was under challenge before the Honorable Court. That is under judgment, my lord, 2014 6 GLR 2747.
Yes.
Well, para 6-8, my lord, at page 750.
Para
8.
8. Yes.
The impugned office memorandum shows that the proposed permit is to be issued under Assam Minor Mineral Construction Rules 1994. The said rules have been framed under Mines and Minerals Regulation and Development Act 1957. Mines and minerals have been defined under Rule 2E of the said rules, which shows that definition under Section 3E of the Mining Mineral Development Regulation Act 1957 has been adopted by the Assam rules. Except Rule 31, no other rules are available in the said section or rules for grinding permits or to any unit involving minor minerals engaged in collecting stone mineral materials. It is tied true that under Rule 31 of the rules, there is no minimum quantity prescribed to obtain permission under Form L of the rules for Rule 31(1). Rather, there is a prohibition against granting of permit exceeding 3,000 cubic meter in quantity under any one permit. there is an upper limit and no lower limit or eligibility criteria has been laid down under the rules. Rule 34 lays down the condition on which mining permits should be granted. Mining, on other hand, have been defined under Rule 2F of the rules as an activity to extract the mining mineral by surface quarrying or by underground method of scraping, digging, picking, or boring, or by any other means. Mining permit has also been defined under the rules. The same is meaning granting extraction and removal of the explicit quantity of any mining minerals from the specific area. It is clear case of Krishna that he runs a crushing unit by collecting and purchasing stones from various leases of Mahal who are licensed under the 11th law for extraction and removal. A stone crusher unit is itself engaged in removal and extraction of the mining mineral in the event of a permit under Rule 31 of the rules may be necessary for him. But in any other case, when a stone crusher unit is not extracting or removing any minor mineral, would come under the purview of Rule 31 of the rules. The rules, as referred to above, does not appear to contain any provision for removing permit to stone crusher units. There is no provision for regulating business of stone crusher unit in these rules. The rules only contain provision for the purpose of extraction and removal of mines and minerals within the meaning of Section 3E of the Mines and Minerals Development Regulation Act. On the other hand, as annexure in Annexure A, a permit has to be issued to the petitioner for the purpose of running the stone crusher unit, which was to be issued under the permission of the SDO civil and not under any authority of the mining department. Annexure A, therefore, cannot be construed to be one of the under Assam Minor Mineral Development Regulation Act 1957. Moreover, the terms and conditions are also mentioned in the said Annexure A. If the contention of the petitioner that the Annexure A has been extended from time to time to is correct, then the same terms and conditions may also be applicable to petitioner. As such, there is no question of incorporation of the terms and conditions therein. Office memorandum dated 22/9/2005 referred to above speaks for issuance of permits under Assam Minor Mineral Concession Rules 1994, which on the other hand does not contain any provision for granting of permits to the stone crusher unit. Even if it is presumed that under Rule 31 of the rules would govern the granting of permission to the stone crusher units, are apparently Office memorandum dated 22/9/2005 shall be hit by Rule 31 of the rules, inasmuch as the said rule does not contain any lower limit as the eligibility criteria for granting permit to stone crusher unit. Rather, the said rule provides for 3,000 cubic meter per year as upper limit. And the circumstance, apparently the Office memorandum so and so. So my lord, is contravention of 31(1) rule, minor rule. As such, Office memorandum adjudged ultra-virus illegal and accordingly. So here, my lord, they have another rule, my lord, stone crusher under this minor mineral concession rule, and that has been held to be illegal, my lord, and possible. So my humble submission, my lord, that that 2003 notification will not apply so far minor minerals are concerned. It is only, my lord, 2020 rules will apply, and 2020 rules you also have seen, my lord, that they can
You are saying that this Assam Minor Mineral Concession Rules 2013 will not apply.
minor mineral concession rule 13 will apply for the, my lord, mines, extraction of mines, my lord, because concessions are granted under that rule. 2003, my lord, notification will not apply so far minor minerals are concerned. My lord, in the 2020 rules, my lord, they can process also, my lord, that is there. 7, condition 7(2). Process includes, my lord, crushing of the minerals.
Where is that 2003 rules?
2020 rules, 7.
These are regulations.
Oh, 21.
2020 rules, yes.
21.
21, it was notified, rule is 20.
20. Rule is 20, 21 is not valid.
Assam mineral regulations and dealers.
Where will I get it?
That's a loose
Well, I
copy,
have
ma'am.
given one copy, my lord, your lordship just seen, my lord, I can give this book also. My lord.
Just.
Yeah, just your lordship seen, my lord. No, no.
2013.
2020 rules. The lordship just seen. My lord, that book, my lord, the second flag is there, my lord, second flag.
Page 365. ma'am.
The lordship is rule 7, my lord.
You are referring to this pages.
No, no, my lord, the rule, my lord. The
No, rules have
2020
seen that,
rules.
but you are saying that you have given it.
My lord, the Assam Gazette, my lord, this is. Assam Gazette, just your lordship has seen also, my lord.
Assam Gazette is
Your lordship has seen, my lord.
2013. I'm just trying to find out.
No, not 13, my lord, this 20 also your lordship has seen, my lord. I placed it, my lord.
Sorry.
Might be, my lord, the 7 files are there.
No, but-
Might have been mingled, my lord.
It was in this compilation.
No, 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 not that one. Not that, my lord.
13.
Your lordship may see from.
Ah,
the
yes,
book,
it is there. 2000. No, this is 15.
No, that is different. That is different. That is not there, my lord. That is only for the purpose of the amendments, my lord, met. Anyway, your lordship may just see from the book, my lord.
No, I've seen that, but
That is just,
I must
my lord,
put a
I
copy.
placed it, that, my lord.
Huh?
After, before some time I have placed this. Because for the purpose of,
No, I don't know, 21 I said.
yes, that 21, my lord, that notified in 21, that 2020 rules. Assam Gazette,
Ah, this one.
yes.
Ah, okay.
Yes. My lord, rule 7 conditions.
Rule 7 is conditions.
Conditions.
Okay.
My lord, here conditions are, my lord, specified, my lord, if you will see from the book also. Rule 7. Strict rules are from my lord. Rule 2, my lord. Roman 2. The dealers, you also got it, my lord. Rule 7.
Ah, yes, it's same. Ah, okay. Now I get it. Huh?
Rule 7.
Yes, that, you have placed.
The dealer shall maintain correct and intelligible accounts of minerals procured, stored, stock, processed, and dispatched to defined destination in Form F. Your losses may at the same time just see the Form F also, my lord. This is Department of Mineral, they issue it, my lord. We have to give, my lord.
Yes,
So everything are, my lord, foolproof. Then, my lord, 3, the dealer shall submit copies of here, my lord, 2, I want to, my lord, stock processed. We can process it, my lord. Process includes, my lord, custody. So no, nothing, no separate is required, my lord. 3, dealers shall submit copies of Form E to the Director of Geology, Mining, Government, Assam quarterly. E also, my lord, that's a detail, my lord, we have to give it. Your lordship may see just E.
yes,
Opening balance of minerals, so and so, so and so, many. Then quantity of mineral or received at a plant. It may be, my lord, at the crushing plant also. Everything, my lord, they have. We have to submit those forms, my lord.
yes.
Then your losses may come to condition 4. While removing the minerals from the stock or factories, my lord, include factories also, my lord. The dealer shall obtain permission from the Director, Geology and Mining, Government of Assam, and transport the materials under prescribed transport challan in Form D, obtained from the Director, Geology and Mining, Government of Assam. What more? Condition number 4 is very important, and that D, my lord, that is the transport challan, my lord. We have to obtain from the mineral department, my lord. Then 5, dealer shall maintain daily stock and transport register in Form M and submit monthly return in Form H to Director of Geology, Mining, Government of Assam. Well, then dealer shall allow that any competent officer to inspect the stores and factories to verify the stock of material, take sample or abstract from the records maintained by him. Dealer shall allow the competent officer, any officer by Director of Geology, Mining, Government of Assam, Secretary, Mines and Mineral Department, Government of Assam, to enter and inspect premises where the furnishing of information as directed in writing shall be obligatory for such dealer. The competent officer or officer authorized by the aforesaid authority in their behalf shall be competent to search any place in which there is reason to believe that any offence is committed and seize any stock of mineral in respect of which offence has been or is being committed. Department is empowered to issue executive instruction as and when necessary. So this rule has given power to issue executive instruction also for proper implementation of the rules. Then penalties are prescribed. Then seizure, confiscation, custodial seizure, for everything is there. So this is a foolproof rule, my lord. They have made under section 23C. And this power has not been, my lord, given to the forest department. Once, my lord, mineral is extracted from the mines, their power ceases. My lord.
So your argument is that this does not discriminate between Schedule X and Schedule Y.
Yes. No. This is, my lord, all minerals, all minerals. And I have already shown the definition of mineral also. All minerals are included. So the forest department is only empowered, my lord, under the minor mineral concession rule to grant leases, permits, etc., and to issue transit passes for removal of the minerals from the mines. Except that, my lord, the transit pass is nowhere is it here. Only once, my lord, transit pass is required. And we have shown, my lord.
Short submissions, madam. Regarding the
It's
applicability
already
of the,
over.
my lord.
I think good things must come to an end.
I already had taken so much of time. So my lord, one submission, my lord, that this Assam Mineral Regulation Dealers Rule 2020 is applicable in respect of stone, my lord. In my humble submission, my lord, with greatest respect, it's unfounded, my lord. Rather, it is misleading, my lord, because for that, my lord, I would like to take your lordship to the concession rules for a moment. 2013 concession rules, my lord. It's basically, my lord, it's a desperate attempt by the petitioners that they should not be controlled by the state and they will do whatever they want to do. For example, my lord, they are saying state has no authority to control, my lord, stone crusher units. My lord, there are stone crusher units, my lord, stopped by the state and as well as by the Honorable Supreme Court, which are lying in the eco-sensitive zone of Kaziranga. If we don't have any control, my lord, then we cannot control them also. Anybody and everybody will construct a stone crusher unit and will say that we are not empowered to do it, my lord. Mineral Concession Rules 2013 for a moment, my lord.
Because you see, there must be clarity in your, in the action of the state.
So that is why, my lord,
If it is a minor mineral, you have your own channel for minor mineral.
yes, my lord.
If it's a forest produce, have it a separate channel. But
Hello.
here what is happening is that there's the overlapping use of power.
That was, my lord, the precisely point in Kumar Crusher case, my lord. There will be a point of overlapping, my lord. But that is, my lord, we are not enforcing in each other's, my lord, judicial competence, my lord. Because that has been clearly held, my lord. Because mineral concession rule, my lord, or the MMDR Act pertains to, my lord, regulation of minerals. Stone being a mineral or as well as being a forest produce, my lord, the forest department will come in not only through MMDR Act, but also in some forest regulation to the extent the control of forest produce is concerned. If it is brought in or found in the forest, my lord. That
No,
is
there
permissible.
I'm not been able to be convinced because you see, when something is extracted as a MMDR
My lord.
under the MMDR Act, then to say that since the items are same and therefore the forest takes up in the forest under the forest regulation, that is something which will be too much. Because if X is doing business solely on the basis of the mineral concession granted under the MMDR Act, he is not required to have a what you call the forest department taking a control over him. Because then it's not an ease of business concept which is now setting in. You see, you are a lawyer. You know that you are governed under the what you call Advocates Act 1961, and then you are proceeding. Think of a situation where there are 5 or 6 acts or 2 acts which are overlapping, and then you have to comply with
All the acts.
both the acts. And then to perform your duty as a officer of the court, that would be something too much. So if somebody extracts a mineral and can demonstrate that he has done it under the MMDR Act, then he must have a separate channel.
In fact, precisely that was my argument, my lord. This section 23C empowers forest department under the concession act, my lord, concession rules to have control over the stone, my lord. But my second argument was that if they come with an argument that we do not have any control over stone, then, my lord, will fall back to forest regulation. It was to rescue my regulations, my lord. Otherwise, my lord, we are quite competent enough under section
The state has
23C.
the competence, it can come up with the rules.
That was my precise argument, my lord. This rule that they are now relying upon, it's a rule framed by the other authority, ex-civil authority, my lord. So we don't have rule to that extent, my lord. That is why in the absence of rule.
So, Swami, if you are also an authority under the MMDR Act
My lord.
in respect of items which are covered by Schedule Y, and you also are the authority under the Forest Act.
My lord.
So, what is the harm in issuing a specific direction where you stick to your own
True, my
own jurisdiction?
True, my lord.
Because now what is happening is that the sum and substance of argument of Mr. Sahiwara is that he has extracted the minerals as per the MMDR Act. So therefore, if you are the authority to deal with it, you take over the, what you call, create a barrier after which it comes within your control and then
Well,
let
that
there
is
be a single
true,
window.
Forget about my lord 1941, 1891 regulations, my lord. Under the MMDR Act and the 2013 rules, but we are empowered to have control. That control we are exercising through a 2003 notification in the absence of any rule. Yes, it is true, my lord, we have the competence to frame a rule that has not yet been framed. So till a rule is framed, my lord, can they take a plea that there is no rule and that this executive instruction, we cannot bind them, my lord? We'll make a rule, no issue, my lord. But till the rule is framed, my lord, can they take a plea that executive instruction will not hold the field, my lord?
No, and you see that there has been the order of this court where the executive instructions.
That was
absence
in the
of rules.
context of 1994 concession rules. My lord will kindly appreciate 1994 concession rules, and I'm trying to take power from MMDR Act, my lord, not rule. That was set aside, not exactly on this ground, my lord. That was set aside because it was purportedly framed under 1994 rules. Now we are not framing any rules under 2013 rules. We are, I'm taking help of Act of 1957, my lord, MMDR Act, Section 23C. So that argument, my lord, to negate this stand, my lord, will not sustain, my lord. For a moment, my lord will kindly take up mineral concession rules 2013, my lord.
Yes.
Section 2. Section 2, 1E, the definition of competent authority.
Yes,
Competent
this-
authority means the director of geology and mining in mining Assam in respect of minor mineral as listed in Schedule X, or the PCCF and head of forest force in respect of minor minerals as listed in Schedule Y, or any other so and so authority to be specified. So there are two competent authority. One is the director of geology, one is PCCF of. Director of geology is for X schedule item, PCCF is for Y schedule item. Now, if we turn to my lord, section 3, my lord.
You just at the same time, you just come to this X and Y.
My lord. Schedule X says, my lord, serial number 1, building stone, including granite, when used for the purpose of manufacture of polished tiles, slabs, and other
Correct.
decorative and
So
architectural.
this is the only power which the MMDR has. The
Right.
Director of Geology Mining has control over this.
Yes.
Now you are referring to the gravel.
Everything, my lord.
No,
Lime
forget-
shell,
For the time being, this gravel and boulder,
my lord.
these are the two items which are in issue here, right?
Yes, my lord. That is from Schedule Y, my lord.
Yes.
Boulder, shingle, then road metal, then slate and shell. These are all, my lord, either sedimentary rock or, my lord, metamorphic rock, my lord.
Correct. So if this is extracted under the MMDR Act by grant of a mining lease by the MMDR, then under which mechanism you are taking control of the?
Firstly, my lord, for the extraction purpose, 2013 concession rules will take care of, my lord, for the lessee of these mineral concession areas. Once it is coming out from the lessee and it is processed in a stone crusher unit, then send it to the open market, then it will be governed by 2003 regulations, my lord. I'm not taking recourse to forest regulations for the time being, my lord. 2003 regulation is saved by this act itself, my lord. Section 23C. Just by creating a confusion that whether stone is a forest produce or not, they also cannot get rid of this. I also admit, my lord, that there is no dispute that stone is a minor mineral, my lord, over which we have control. Schedule Y. Now, my lord, section 3, my lord, will kindly see.
Rule 3.
Rule 3, my lord, 2013 rules. It says, my lord, a mining lease or a mining contract or permit or any other concession or license or transit pass, my lord, will kindly take note of this, my lord, transit pass or permit or license or control and or regulation of mining and other actions under these rules shall be granted taken by number 1, a director in respect of minor minerals for industrial and specific use as specified in Civil Acts. So the director will issue inter alia the transit passes also. B, the principal chief conservator of forest and head of forest force or any other so and so in this behalf in respect of minor mineral for uses other than in industry as specified in Schedule Y. So my lord, now let us come to the rule, my lord. Rule of 2020, notified on 18th of February 2021. Eighteenth of February 2021. This rule, my lord, and kindly see definition 2B, 2(1)B. Competent authority means any gazetted officer not below the rank of Deputy Director of Directorate of Geology and Mining Assam as authorized by the government in Mines and Minerals Department. Before that, my lord, kindly see that how under what authority this regulation was rule was framed. By. In exercise of powers conferred under section 23C(1) and 2 of the Mines and Mineral Development and Regulation Act 1957, the Governor of Assam is hereby pleased to make the following rules to regulate possession, storage, trading, and transport of minerals and mineral produce, to check any evasion of royalty and sayonara fee, stopping of illegal mining and transportation in the state of Assam and the purpose connected therewith. It was a rule framed under 1957 Act. Competent authority is, my lord, is the director. Then, my lord, will next turn to the next page, my lord. The competent officer means a gazetted officer authorized by the Deputy Commissioner of any district and Director of Geology and Mining. But entire forest department is missing. So if we accept the argument that this rule also governs Schedule Y items, my lord, in effect, my lord, forest department has been eliminated. They or otherwise, my lord, they are encroaching under the power of the forest department. Then only, my lord, this rule becomes applicable. My lord, will kindly see definition of mineral at K, my lord. Mineral means
No, you say you are the state, you are framing a rule.
no, here, my lord,
The
because
legislature and so the executive understands what they are doing.
yes, executive understands that this is a rule frame for the geology department for Schedule Y item, X items. My lord. But the petitioner wants that this will govern Schedule Y items. My lord. We have no confusion. The confusion has been created by the petitioner. We have made this rule for the geology and for the Y Schedule items, my lord. This rule of governing these regulations, my lord, are yet to be. That is why I am falling back to the 2003 regulations. State is without any confusion, my lord. But if the argument of the petitioner is to be accepted, then, my lord, state has directly, my lord, allowed geology department to encroach upon forest department, my lord, which is not the fact, not the intent of these regulations also, my lord. Then, my lord, will see section rule 3, my lord. All mineral dealers shall register
You're saying
themselves.
that it does not follow, and therefore you are referring back to this 2013 rules.
My lord, 13 rules clearly defines X and Y. 13 rule was also framed under section 15 and 23C. Section 15 precisely, my lord. Rule 3 says all mineral dealers shall register themselves as dealers under the Directorate of Geology and Mining, Government of Assam, as per the procedure mentioned in these rules. So forest department is completely missing, my lord. This rule, my lord, is framed to govern other minerals, my lord, which are not listed as Y schedule items, my lord. To, my lord, clarify that, my lord, will kindly see the definition of minerals, my lord. Again, my lord.
It's okay, not required.
Because, my lord, this definition
Definition.
take back us to, my lord, the 1957 Act, my lord. That these schedules. And none of those schedule incorporates any of the minor minerals listed for forest department. So this rule has no application whatsoever as regards Y schedule items are concerned. Everywhere it is Director of Geology.
Okay.
Then they could have also, my lord, obtained a permit under these rules, my lord, because they will not get getting it for forest stone, my lord.
We shall take.
For no, how can they get it, my lord? Because for stone is not a mineral under this act, rule, my lord. So
No, he has
gate,
shown that, he has shown that,
what, my lord?
in the repetition, he has shown that he has got the permit.
He has got the permit, my lord, for the other minerals, not stone. He cannot crush stone on a basis of a license issued by geology department. It's clear. He cannot crush a stone, which is a Schedule Y item, on the basis of a license issued by a civil authority under Schedule X.
This is what we have to adjudicate.
Yes, ma'am. That's what, my lord, I'm trying to persuade, my lord.
Okay.
Next, my lord, just one more submission, my lord. Otherwise, my lord, most of the points, my lord, I have already pointed out, my lord, that I will be heavily relying on this Kumao case, my lord, wherein, my lord, stone crusher was also an issue. Transit permit on stone crusher was put to challenge. Issue was also, my lord, to the extent, my lord, the conflict between the 1957 Central Act and the Forest Act of 1927. And both will survive was the ratio of the Honorable Apex Court.
Okay.
I think this will do, my lord.
Just here the facts I am dictating.
My lord also can consider my written argument. One more submission, my lord, this item number, this writ
This
petition.
limestone, I'll take it up next, not
Well,
today.
Not today,
Limestone,
but I'm also not prepared today. That's why I'm, that is, my lord, WPC number will be 6603 of 2019.
Okay.
SLD infracom, my lord. That may be taken up some other day.
In this writ petition, Mr. Saiwala,
Yes,
in this bunch, we are taking up 5052 and 1357, two matters,
3 meters.
And one is, my lord, 6542, my lord,
6542.
of 2022. Wherein, my lord, we have closed the, my lord, license. Suspend.
So in WPC 5052, 1357 of 2015, 5052 or 22. 1357 of 2015 and 6542 of 2000,
6544, my lord,
6544
of 2022. my lord.
or 2022.
Two.
Submissions of Mr. G.N. Saiwala, Senior Counsel. In the case of the petitioners is that
My lord, may I leave? My lord?
I'm dictating the facts so that there's no confusion on facts. The case of the petition is that they purchase stone from stone quarries who are having mining lease, mining contract or quarry permit issued by the competent authorities under the Mines and Minerals within bracket Development and Regulation within bracket closed Act 1957 within bracket MMDR Act for short. The stones which were extracted are covered by the transit passes issued by the forest range officer concerned. Which indicate that the type of mineral for which transit passes were issued are stone gravel and stone. Stop. The trucks by which the stones which were broken in the stone crusher units were purchased by the petitioners and transported. And in course of transported by were purchased and transported. So in course of transportation, the trucks of the petitioners were seized and detained in the concerned range office of the forest department. Full stop. The grievance of the petitioners is that no seizure list or documents were no seizure list was provided to the truck drivers. However, penalty tickets were issued by the division officer of the forest department. Leaving huge penalty of rupees 50,000 or more. Next paragraph. It is submitted that the provisions of the MMDR Act and rules framed thereunder require the stone quarried from the various mines to be transported, carrying the requisite proof of transit passes being issued by the authorities, by the competent authorities. Accordingly, it is submitted that there is the stone aggregate which was being transported on the basis of a valid invoice from the issued by the registered dealer of the minor minerals. The forest authorities could not have put fetters on the right of the petitioner to trade in such minor minerals. First of all, it is the case of the petitioners that the provisions of section 63, 64, within bracket I, and 73 of the Assam Minor Mineral Concession Rules, 2013 is not applicable. And that the provisions of section 20 of section 23C of the MMDR Act provides power to the state to frame rules to control illegal mining, which cannot be extended to transportation of minor minerals. Next, by referring to the case of Kumar stone pressure, it is submitted that the stone which was being transported by the petitioner were mined under the MMDR Act, and it was not not an item which was inverted commas brought from forest within the meaning of section 3(4)(d) of the Assam Forest Regulation 1891. And therefore, the Environment Forest Department of the state could not have exercised power under the Assam Forest Regulation to seize the stones and impose fine by treating it as a illegal sale of forest produce, illegal transportation of forest produce. Next paragraph. It is by referring to the provision of section 15. Of the MMDR Act. It is submitted that 15 within bracket 1. It is submitted that the words invert commas purposes connected therewith invert comma post must be read by applying the principle of adjustum generis and must be read along with the preceding words, which includes quarry leases, mining leases, or other mineral concessions in respect of the minor minerals. And by referring to entry 55 of the second schedule of the Assam Minor Mineral Concession Rules, 2013. No, sorry, this is MMDR Act. of the MMDR Act. Comment is submitted that all other minerals not specified in Schedule 2 thereof would include stone, which is not specifically mentioned in the second schedule. Hence, comment is submitted that the forest department of the state, which had no power to control transportation of trade and transportation of stone, which is an exclusive item covered by the MMDR Act. In the said context, it is also submitted that the state has notified the Assam Minerals Regulation and Dealers Rules, 2020, where the Directorate of Geology and Mining is the competent authority within the meaning of Rule 2(1)(b) and that the said rules having been framed in exercise of power conferred under section 23 within bracket capital C within bracket numerical 1 and 2 of the MMDR Act, excluded jurisdiction of the Forest Department to interfere in the trade and transportation, storage and transportation of the stone being which was being carried on behalf of the petitioner. It is also submitted that the power to make rules can only be exercised for purposes related to mining and not for any other purposes. Mr. Dega, in this writ petition 5052, why was this page 76 referred to that the affidavit, that notification of 29 January 2003, what was the context?
Well, this 29th of January 2023.
29 January
This
2003.
is the regulation by which stone crushers are being
No,
regulated.
Mr. Saivara
Yes.
made the submission. I have recorded this, but what was the submission? I did not record.
But they have challenged this.
No, that has been challenging.
That is challenged in the other writ petition.
Okay. Accordingly, it is, according to the petition is also challenged. The notification dated 29/1/2003. Which provides that no stone crusher shall be installed in the state without obtaining a permit from the government in the forest department. Page 76. Just look. In support of the submissions made. Judgment is good. The Honorable Senior Counsel for the petitioner is referred to the following cases. State of Gujarat and others. 2019 16 SCC 513. 2014 6 GLR 747. 2009 3 GLR 586. Kumau stone crusher. Two 2019 16 SCC 513. That's all.
Yes.
Well, contract, comma. It's just like submissions of Mr. P. N. Goswami, additional AG.
A written argument may be considered.
Written agreement to cancel.
That's right.
This is the.
Yes.
Understood. The learned additional AG has submitted a written argument which is kept on record. He has submitted that the stone is a specific item which is contained in Schedule Y of the Assam Mineral Concession Rules 2013. Mr. It has been submitted that the definition of forest produce at section 3 within bracket 4 of the Assam Forest Regulation is identical to the definition of forest produce provided in section 2 within bracket 4 of the Forest Act 1927. And it is also contended that insofar as items covered by Schedule Y of the Assam Mineral Concession Rules is concerned, the forest, the PCCF, who is the authority? PCCF, the PCCF from HOFF is the competent authority, and that the issuance of license, etc., license and permits are covered. Now, is vested with the concerned divisional forest officers.
PCCF and the officers that may be authorized by government.
By the PCCF or any other officer authorized by the government. This includes the DFO,
Yes, sir.
which includes divisional forest officers of the various divisions. So, it is submitted that if the the Assam Mineral Regulation and Dealers Rules 2020 would show that it is not encompassed the forest authorities within its definition, and therefore therefore it is submitted that the intention of the government was very clear in framing the said 2020 rules, which was exclusively made under the made for the regulation of storage and transportation of minor minerals within the within the meaning of Schedule Y of the Assam Minor Mineral Concession Rules. Hence, Committee submitted that for the purpose of regulating the business storage and transportation of items covered by Schedule Y, the forest authorities draw their power under the Assam Forest Regulation and which rules? 2000
Concession rules 2013.
and the Assam Minor Mineral Concession Rules 2013. Why do you refer to this entry 54 of Schedule 7 of Constitution?
Because my lord, the MMDR Act, my lord, that mines and mineral, the section 2 of MMDR Act, my lord.
2 of MMDR Act.
There's a declaration to that effect, my lord. In terms of entry 54, my lord. Declaration as to the expediency of union control.
Okay.
Despite this, my lord, Indian Forest Act was upheld, my lord. When there was some incidental enforcement, my lord.
By referring to the provision of entry 54 of Schedule 7 of the Constitution of India. The learned AG has referred to section 2 of the Mines and Mineral within bracket Development and Regulation, MMDR Act. The project that despite declaration in the said section as to the exclusive control of the regulation of mines and development of minerals by the union government, comma, the by judicial pronouncement of the Supreme Court of India, comma, the provisions of Forest Act, 1927. So far as incidental or accidental, which is there, accidental.
Incidental.
Incidental encroachment.
Occurrence in separate fields. That's the
The
part.
incidental encroachment on the MMDR Act was by the forest authorities was upheld. Where is the notification you were referring to
Oh, my lord.
of the forest authorities? You are saying that you had that power.
2009 notification, well, that's in the Forest Act. In my written argument, it's also there, my lord. Page 42 of my written argument.
42,
my lord.
Therefore, committee submitted that in view of the various provisions of the Assam Forest Regulation, 1891. The government of Assam had issued a notification dated 1/9/2009. Thereby notifying the schedule of rates of royalty leviable on all classes of forest produce in the state. Which includes rates for sand, gravel, and stone. So, thus, the submissions of the learned additional AGs to the effect that not only under the Forest Act, 1927, or but also under the Assam Forest Regulation 1891 and the Assam Minor Mineral Concession Rules 2013. The Forest Department would have control over items which are exclusively reserved for the Forest Department under Schedule Y of the Assam Mineral Concession Rules. And therefore can issue notifications to prevent illegal mining, transportation, and storage of such forest produce. That's all. In support of his submissions, Reliance is placed in the following cases. Mr. Goswami,
It's there in the index, my lord. That means I have already mentioned.
it's in the index.
And one more
It-
submission, my lord, was that one more submission was that, my lord, by invoking the doctrine of implied power, my lord, our 2003 regulation is saved by section 15 and 23C of the MMDR Act.
It is further submitted that by applying the doctrine of
Implied power, my lord,
implied power.
The regulation of 2003,
By invoking the provisions of section
15 and 23C of the MMDR Act.
15 and 23C of the MMDR Act, the
3 regulation of stone crusher unit. Is saved,
2003 regulation of the stone crusher unit is
Saved.
saved. You know, Mr. G. N. Savada, assisted by Mr. P. Deca, counsel to the petitioner, and Mr. P. N. Goswami, additional AG, assisted by Mr. R. Gogoi, standing counsel for the Forest Department, are judgment reserved. And in this other matters, we fix a date after week for other matters, limestone matters. Which are those items?
That is, my lord.
There are 3 matters altogether today that have been heard. One is for limestone.
So Dekha, you'll have to button up your coat first.
My lord, limestone is, my lord, 6603 of 2019. Item number will be, my lord,
Huh.
4. Item number
Item
4,
That will only come.
that will again come.
We'll fix it next week. When is convenient to both of you?
Any date, ma'am.
29.
29/8.
29, ma'am.
Take a break and come back. Yes.
Lord, here in this case, we are candidates of veterinary field assistant training course. In the year 2017, there was an advertisement to get into training of that course. Now, the advertisement which was they have published during 2017, there the minimum educational qualification, they have made it as a higher secondary with science and biology as one of the subject. That was challenged in the earlier writ petition. My lord. And the Honorable Court, after hearing the parties, was pleased to dispose that case, my lord. Earlier writ petition, that is, your lordship will find at page 32, sorry, no, page
3411 portion.
25, and the relevant part is from 34. That will clear the entire thing. No?
Page 34.
Page 34.
Mr. Sinha,
Yes, madam.
your candidature was rejected because of overage. That is the ground.
Overage and also some certificate not disclosed, not submitted, all these things. Now, whether we were overage, we were overaged and the order passed by this honorable court in the earlier petition, if they are overaged, they will be condoned.
No, for condemnation, you'll have to apply before the competent authority for condoning the overage. Have you done that?
No. The court, honorable court, that if they are within the stipulated age, if they are within the stipulated during the time of advertisement of 1117, that was the views of the court, madam. Your lordship will find just, my lord, the page 34, para 3, my lord, para 3 of the order, my lord.
Yes.
Yes, an advertisement was issued on so and so, inviting applicants for eligible male candidates for undergoing the same course for 2017-18 session. The criteria of eligibility mentioned in the said advertisement read as follows: entry qualification, minimum eligible question required for admission is so and so with biology subject number so and so, so and so, so and so. Then, my lord, this was, my lord, the honorable court has come to the findings at page the next page, para 5, man. The rule has been amended. By amended rule, the qualification has been upgraded to higher secondary science. Now, the observation given by this honorable court, para 5, may I read, man? The state has filed the affidavit in opposition stating that the advertisement was issued as per the amended rules as notified on 6/7/2017. It has, however, been submitted by learned senior counsel for the petitioner that though the rules may have been notified on 6/7/17, in the same notification, it has been provided that these amendments shall come into effect from the date of publication in the official gazette. Learned additional senior government advocate has produced a copy of the said official gazette today, which shows that said notification dated 6/7/17 was published on 19/8/17. Accordingly, though the said notification was issued on 6/7/17, it can be enforced only from 19/8/17 and not prior to that. And since the said advertisement was issued on 29/7/17, the said advertisement could not have incorporated the amended rules, which would come to effect only from the date of publication in the official gazette, that is 19/8/17. Now, next paragraph also is important, man. In that view of the matter, this court is the opinion that the authorities could not have insisted upon the aforesaid amendment qualification from an earlier date before it became effective, and since the petitioners claimed that they were all eligible for undergoing aforesaid course prior to coming into force of the aforesaid amendment, and since there were vacancies at the relevant time, they would have a legitimate claim for being considered for the undergoing the aforesaid course. In view of the reason discussed above, the present petition is allowed with the direction to the respondent authorities to allow the petitioners to undergo the aforesaid training course in the next session, provided they are otherwise found eligible as per old unamended rules, for which the petitioner will submit detailed application individually before the authorities so that the authorities can pass appropriate order for allowing them to take part in the next training session or when the same is advertised. Since the training session in terms of improving advertisement is going to complete by the end of November 19. In the meantime, if any petitioners become overaged during the pendency of this petition, the said age bar may not be taken into consideration provided they were eligible and within the stipulated age when the improving advertisement was issued on 1/1/17. So this was the, my lord, direction. Then, my lord, the next advertisement they have made where our candidature has been considered by the authorities, there is page 37. Your lordship will find in the second paragraph. However, the 45 numbers of petitioners as per order of the Honorable High Court dated so and so in the writ petition number so and so, if otherwise eligible, should collect hard copy of application from the Directorate of AH and Veterinary or Office of the Principal School Veterinary School so and so teacher, submit filled in application form along with postal order and testimonials either by hand or by the so and so so and so. So our these 45 candidates have submitted their applications pursuant to this new advertisement where our candidature or we have been allowed to submit our application form. Then this 33 rejected, a list of rejected candidates has been published. Then we were rejected on the ground of overage, or invalid submission of certificate of EWS or IP or something like that.
But then look at page 42. They are calculating date as per 1/1/2017. So what is wrong?
But here we are held as overage. Now they have considered it to be the maximum age of 30 years. But the entire repetition is past that the maximum age is 43 years. Unamended as per unamended rules. They have remained as per earlier advertisement in the next annexure 3, that is page 37. Age, even though educational qualification they have condoned, but this court has said that it is a gazette notification was come later on.
Where is
Why-
the real earlier advertisement?
Earlier advertisement, my lord, I have not enclosed here.
Then how will I find it that what was the age at that point of time?
That is, my lord, that is not where, nowhere it is even in the affidavit opposition they filed that did not mention. We did not get it, mother. What was the earlier advertisement? No, sorry. Earlier advertisement. Hmm. Or your lordship may call for that writ petition, my lord. That writ petition, earlier writ petition in the record, my lord. With this case, my lord.
Which is a duly represented. The registry shall call for, shall tag the records of WBC 2837 of 2018, which was disposed of by order dated 24/5/2019.
29.
Huh?
24.
24,
24/5/2019.
sorry, 24, my lord, sorry. 24.
List will be next week.
My lord.
Any date may be fixed, my lord.
Uh,
Three zero.
30. 8.
Maybe Pathat, my lord. Pathat.
No, I'm not giving it back.
Obliged.
May it please your lordship. May it please your lordship, in this matter, pleadings are complete. Lordship may fix this matter for admission hearing. In this matter, pleadings are complete.
This is fixed for admission only.
Hearing, lordship.
You want adjournment today?
Yes, lordship.
Both sides are duly represented on the prayer made by land counsel for the petitioner. Matter stands adjourned today.
Yes, ma'am.
List on.
September.
Hmm?
13 September.
13 September 2023. Yes, was it sent for class scrutiny? Yeah.
In terms of said lordship, now new judgment has been come in the month of May, lordship, passed by CJI and Justice Pardiwala. That is, once it is wrong from the beginning, it is void ab initio. Let me go through it. Bhubaneswar Development Authority versus Madhumita Das, lordship.
Okay.
That Shalini is also overruled. Shalini's decision has also been overruled here.
Overruled.
Overruled, lordship.
What is the citation?
Citation and not it is.
What is the name?
I have the civil appeal number 3320 of 2023.
No, just give me the name if I can track.
Bhubaneswar Development Authority versus Madhumita Das.
Just
Means once you have deprived, you are not entitled, you have deprived others. Being void ab initio. It was cancelled by the Tehsildar, not by the cast lordship. In that case, lordship. Let me also go through it.
This is Adhikanda Biswal.
Bhubaneswar Development Authority versus Madhumita Das, lordship.
I don't have it. Okay, we'll take it up after.
Item number 8.
Yes.
Made. In this election petition, we have filed 3 IAs.
So Das is not there.
I understand things, much water has flown in the river in the meantime after filing of this election petition. What has happened? I remember paragraph 12 of Azhar Hussain that something is kept as a sort of sword of Damocles on a return candidate so as to sufficiently and effectively dissuade him from discharging public duties. That becomes, I have filed 3 IAs. 1 IA is under Order 7, Rule 11. Next IA is for deferring the filing of the, that is 1982 is the 1983.
You can wait for some time. Let Mr. Das and somebody be there for the election petition. We'll take it out after 5 minutes because it is this application which is creating a headache for me.
My lord.
Order 7 Rule 11. Because 2 orders have passed. Both the orders have been contested in the Supreme Court.
That is usual method.
And before there are the 3 matters where I've
Oh, the issues are same then.
issues are same.
And it has been made more complicated. An Order 7 application which is pending in respect of the same return candidate. In verbatim the same election petition, again filed after 1.5 years. That way the matters do not, because that's why we have filed 3 IAs now.
I don't know, that is the only what you call bad spot I am having. Because
It cannot be, my lord. It should not be treated like a black spot. Because
no,
ultimately,
not that. No, not the challenge before Supreme Court, not that. Because in other 3 matters, the issues are same. It will be the same ratio, more or less it will be
more or
covered.
less same.
So therefore, I have not been able to pick up my pen and then.
Most probably, in one election petition, there is an interesting issue regarding applicability of COVID order and all. There is an interesting issue, but that was not very much contested as I expected, with all due regards to everybody. But that was a very interesting
No,
issue.
but because there must be some impetus to use pick up the pen and write the order. So that is somehow that zeal is missing.
Sometimes, my lord. Because those days, election cases means everybody is serious. Now election cases, first few months, people are serious. After that, but your lordship will remember that those days, we have to prepare for the next day. We have to prepare everything.
It was just like a regular civil suit.
Yes, regular. Then we have to
had
prepare application on the order 11 for inspection and interrogatories. Then order 14 for re-examination. Then again, it comes to the Evidence Act. 154, I remember in Hitesh Soika case. Whether what is the difference between a witness getting declared as hostile or re-examination? Because question of leading question was involved. Those days it was election cases means election cases.
That re-examination is under 138.
154 was it?
So 154 is that
I'm sorry.
questioning his own witness.
Your lordship will
No, questioning his own witness.
questioning it. That in that 154, an issue arose whether I can ask a leading question. Since I am asking
Evidence Act.
154 to sound, evidence of consent. Ekon nana election case. Election case evidence of property. My lord, I may be wrong because 154, why I vaguely remember, issue was whether in the re-examination, I can ask a leading question or not. Because otherwise he is a examination in safe, I cannot ask a leading question. 154, because that came up most probably before Justice Hansari, Honorable Justice Hansari or Justice Swakia.
Question by party to own witness.
My lord.
This is a question by party to his own witness, 154.
Yes. So the issue was, I remember vaguely, whether when a witness is recalled again, when I can ask my own witness a leading question. Because he is as good as a thief. I am recalling him. Then that judgment I most probably have. There is a difference that if a witness is recalled after being declared as hostile, I can ask him a leading question. But if he is recalled without anything, I want to re-examine him, that I am debarred from asking him leading question. This issue took almost 1.5 day.
Because here it says, the court may in its discretion permit the person who calls a witness to put any question to him, which might be put in cross-examination by adverse party.
Then the issue was, I called with the permission, but he was not declared as hostile.
Huh.
So then it went against me that you cannot ask him a leading question. Because I wanted to take a plea that now I am recalling him. He is in cross-examination, therefore I can ask him a leading question.
No, but recalling, that's what I'm saying. Recalling is under 138.
138.
So because that would not be under 154.
I'm sorry, because now after all these 20 years, I was out of this.
No, it's okay.
It
But,
has gone out of.
but when it is 154, then you can ask questions. But it is only under when it is recalled under 138, then perhaps you're not
Most
permitted.
probably, I scared the witness by saying that, do you know the consequence of section 195 and 195 those days, most probably IPC. Then I made him to read election case. Then now you tell me.
Yes.
May please, Your Lordship. Lordship saying counsel is not in court today. I am appearing on behalf of Mr. D. Das in this matter. He's on legs in court number 14. If it is not inconvenient to your lordships, then can it be taken up on some other day?
After some time.
Your lordships, some other date may be given if it is not inconvenient. By the
Because
means.
he has got 3 applications that can't be adjourned.
Lordships,
3
just that
interlocutory applications are there. It can't be adjourned. We'll have to take it up.
Objection diba, then diba.
in that case, your lordships will file an objection. Some time may be given.
So we'll issue notice on these 3 applications. Correct.
Yes, sir.
Uh, in election petition, right, Mr. D. Das, Senior Counsel, assisted by Miss
S. Sharma.
S.
Sharma. Sharma.
Sharma, counsel for the petitioner. And also Mr. K.P. Pathak, the senior counsel, assisted by Mr. A. Barwa, counsel for the respondents. Next paragraph. Respondent. Next paragraph. In view of the 3 interlocutory applications filed in this matter, comma, the which includes interlocutory application for
1982 is for order 7. 1983 is for this.
just which includes application for rejection of election petition. Another is
1982 IA number is order 7. 1983 is for deferring the filing of WS.
for deferring the filing of written statement,
And
and
1984 is for praying for framing of a preliminary issue on the ground of limitation under order 14, rule 2, sub rule 2.
okay, an application for framing preliminary issue on the question of limitation. Full stop. Next, paragraph. Accordingly, in view of orders passed in IA Civil 1982 of 2023, filing of written statement is time is extended for filing of the written statement in this matter. List on so and so. Then in 1982, you write. US Mr. K.V. Pathak for the Das for the opposite party. Next paragraph. If you notice on this interrogatory application filed under order 7 rule 11 CPC, read with section 86 of the Representation of the People Act 1951, which the applicant is praying for, the applicant who is the respondent in the connected election petition is praying for rejection and dismissal of the connected election petition. First of all, objection is, if any, to this interrogatory application be filed within how much time?
4 weeks.
4 weeks will delay the election petition.
6 মাহৰ টাইম এটা থাকে ট্রায়াল হেড কৰিব ঠিক আছে 1 মাহ যদি তাতে লছ হয় না তেতিয়া হেড কৰিব
Lordships, 3 weeks at least, maybe.
3 weeks. Return in 3 weeks. Give a date after 3 weeks.
দেখে তো সাইজ
So and so. List on so and so.
1990.
1983. This election petition adjournment would be on the basis of 1983, not 1982. 1983. 1983. This is an interlocutory application under section 148, read with section 151 CPC, by which the applicant, who is the respondent in the connected election petition, has prayed for recalling of the order dated 23/6/2023 to file written statement in view of application filed under order 8 rule 11 CPC being IA Civil 1982 of 2023. Full stop. Same issue notice. This one. Pending consideration of this application, comma. The filing of written statement in the connected election petition is deferred till the next date of listing, list on so and so. Then 1984. This explicative application is filed under section 151. CPC dealt with order 14, rule 2 CPC. Who is the applicant, who is the respondent in the connected election petition has prayed for framing of a preliminary issue on point of limitation. On the part of limitation that the connected election petition is barred by limitation. The issue notice written up John so and so, objection if any to be filed within date fixed, list on so and so.
DPM.
Continue post lunch.
They have said that order dated 18th was passed by the Honorable Court. Clearly state the response should immediately take up the case of the petitioner for promotion under Assam Public Establishment Service Rules, subject to availability of vacancy. Although students were promoted to the post of senior cadre, senior assistant, right office order number dated 13/7/2000, after receiving the approval from the government of Assam in the Revenue and DM Department by number dated 11/3/2016. But the above mentioned promotion should have been followed before complying as per order dated 18/8/2015 in WPC number so and so. Promote him to the post of LDA under the Assam so and subject to availability of vacancy. And they have also admitted they have not nowhere stated there was no vacancy in the post of LDA man at that point of time.
No, so you see. You'll have to explain whether absence of statement in the affidavit in opposition that there was no vacancy.
Yes.
Would it lead to a presumption that there was a vacancy?
No, they were saying that there was no vacancy. But in orally submission, but in the affidavit, nowhere there's the.
No, that's okay. You see, what I'm asking is,
Yep.
in the absence of any pleading that there was no vacancy,
Yes,
would it lead to a presumption that there was a vacancy? Because presumption of there being a vacancy is not cannot be drawn by the court because you were serving there
and I
in the
understand.
same establishment. You could have said that there was a positive statement that there was a vacancy.
Yes,
Because if you don't make a statement, that would go against the petitioner. Because you are aware that there is no vacancy.
no, actually, I understand my lawyer also, but already because they without complying the order, they have promoted me to the post of senior assistant. That created the problem. Actually, I should have initially promoted the LDA myself. Then after putting qualifying service, then I shall be entitled for promotion as a senior assistant, UBA. Without following the seniority to nothing, my lord, they have simply promoted me to the senior assistant, that is UBA. Now, now already I've retired from service. Now, my case is now my lord, that since I've been working as a UBA, as a senior assistant, that your lordship will find in their page 54 annexure 12, my lord. There your lordship, my details of my posting is stated, my lord.
54.
54. And lecture 12. That you also fact, initially I was appointed community based so and so. I regularized my appointment by the scale of so and so by this order dated 16/9/1988. Again, at letter number so and so, I was transferred to not Guwahati Revenue Circle. And again, by letter date number so and so, I was transferred to Guwahati Revenue Circle. After a few days, I was again transferred to Rongya Revenue Circle by the office letter dated 19/6/92. Reportedly has been entrusted with the charge of Senior Assistant Rongya Revenue Circle with effect from 1/10/2005 due to the vacancy arises to the retirement of Sri Kasidat Kolita on the superintendent, then Senior Assistant Rongya Revenue Circle. So I was working, I was in the charge of Senior Assistant since 1/10/2005. Sri Talukdar submitted a prayer to allow him pro a salary of Senior Assistant from taking over charge of Senior Assistant with effect from 1/10/2005. Same was forwarded to Circle Officer Revenue Circle by letter number so and so. Then by this office letter, dated 19/1/2006, was forwarded to the proposal of Circle Officer Revenue Circle to the Revenue LR Department, Government of Assam, taking instruction regarding allowing so and so to draw the salary of Senior Assistant as paid for, but action could not be taken due to non-receipt of instruction. In the meantime, he was transferred to the office of SDO Civil Rongya and Subdivisional Officer Rongya subsequently made vice versa transfer with Fazlul Haq Chaudhary Senior Assistant, placing in the APP office in the court of SDGM. I lot of so and so. Again, SDO Civil returned him from the APP office to the office of the Circle Officer Rongya Kanaya Revenue Circle in the post of copies. What has happened in this case, your lordship will find, in fact,
Yes.
there is a direction by the ADC, my lord, that your lordship will find. That is page 27, my lord. There you are also a letter issued by ADC Kamrup Aminggaon to the SDO Civil Rongya Subdivision. With reference to above, I have to inform you so and so has submitted an application praying to promote him as a senior assistant as he was transferred posted in office of APO against a senior assistant by your order number so and so. In this connection, you are also informed a High Court case was initiated by so and so seeking to get him promotion to the post of senior assistant is also pending before the High Court. Therefore, you are requested to withdraw so and so. So because of I filed a High Court case, so the ADC directed the SDO, my lord, to withdraw me from the office of the APP and place him in your office or any revenue circle office as a revenue office. So that as a punishment, I was brought back again, man, since I filed a case, man. Accordingly, my lord, on 24/1/2014, my order was issued. I was brought back as a copyist, my lord. In the meantime, the High Court WBC number 137/2015 was disposed of, my lord. So with the approval of the Revenue Department, my I was promoted to the post of senior assistant at Kayan, same revenue circle on 13/7/2016. And I retired from service, that page 53, on 34/2018 on superintendent. Thereafter, my lord, there was another order of the High Court, my lord, that is on 11/12/2018, my lord. And matter was reviewed, my lord, and promotion was given to me with effect from 1/10/2015 against the vacancy arising due to retirement of Abdul Latif.
Okay.
Now, the state government, my lord, by letter dated 18th of September 2021, annexure 3, my lord, annexure 13, my lord,
Page.
have page 56, my lord. Wrote to the Joint Secretary, wrote to the Deputy Commissioner of Kamrup, my lord. A clarification was sought for, my lord. Clarification was sought for, as there was a vacant post of senior assistant as on 1/10/2005, which was fallen vacant due to retirement of Kasinath Kolita. You are requested to clarify why Satyaman Talur was promoted with effect 2015 instead of 2005, which was earlier date, with a vacancy of senior assistant for issue of appropriate instruction in this regard for payment of financial benefit in favor of so and so. Yes. And in reply, my lord, to the joint data, they have given reply that is annexure 14, my lord, page 58, my lord. Their contention is, my lord, the Deputy Commissioner, my lord, page 59, my lord. Then, as you are aware, the senior assistant is a promotional post, filling of vacancy of senior is done every year. Accordingly, this office has filled up the senior assistant, which was fallen vacant on 1/10 due to retirement of so along with others, but date was not given when it was filled up. It is also mentioned that at the time of the order dated 11/12 of the High Court, vacancy against the post senior assistant arose on 1/10/2005, which due to Supremo Conciliator was not considered as same already filled. They are saying that already, but date was not given when it was filled up. This office has reviewed the matter of promotional benefit with effect from 1/10/2015, has come to a conclusion. The prayer of so and so seeking financial benefit with effect 1/12 should not be considered due to non-availability of vacant post of senior assistant. So now, their basically contention is that, my lord, since there is a non-availability of post of senior assistant, again with effect from 1/10/2005, so I am not entitled for promotion. That is the crux of the matter. But when the post of Kasinath Kolita was filled up, that was not stated. So these are my submissions, my lord.
Yes, Mr. Sutia.
Yes, my lord, apparently, my lord, there was no vacancy. That's why, my lord, his case was not, well, he's enough lucky because without being a LDA, he got the senior assistant, my lord. Now, today, my lord, I have received one instruction, my lord, lordship, and I have that has been returned, reduced to return, my lord. Even still today also they say, my lord. As per Gedison list of hierarchy posts along with the vacancy status, government district menial service rule 1967 under the amalgamated establishment of Kamrup as on 1/10/2005 is as follows. Total number of employees including head assistant, sectional assistant, senior assistant, junior assistant under the amalgamated office of the Deputy Commissioner Kamrup, 124 numbers. Strength of a head assistant 1, fill up 1. Strength of supervisory assistant 5, fill up 5, no vacant post. The strength of senior assistant 47, fill up 47. And
No, that
total
is on today.
because my lord,
Oh, sorry, 1/10/2005.
yes, he
Okay.
was not promoted first, not promoted to the post of that is come LDA because there was no post, my lord. And the rule says, my lord, after working 5 years, his case will be considered for that. And rule says So my lord, he was first, he would have been my lord promoted to the post of LDA, typist come LDA as per court's order.
That perhaps we can't reopen because this court said that you promote him.
Because he has already been promoted, my lord, and court's order, my lord, lordship, two writ petition was there. First writ petition was, my lord, this is, my lord, in my page 26, my lord, annex of 6, and last page, my lord, says writ petition 137, 18/8/2015 order. Lordship got it. My lord, court is a view that respondents should immediately take up the case of the petitioner for promotion to the post of office come LDA under another rule 1991 rules, if necessary by antedating the such promotion from the date when the petitioner became eligible for promotion and subject to availability of vacancies in the higher cadre of office come LDA. Once this exercise is complete, petitioner would come within the ambit of 1967 rules. Thereafter, he will come to the rules 1967, District Ministerial Establishment Rule 1967, in the lower rank of LDA. Then he would be entitled to a consideration for the further promotion to the higher cadre of UDA, subject to the court. Without promoting him or without getting the chance of the LDA typist like that, he got the senior assistant. He's a lucky enough, my lord. Straightway he jumped to the senior assistant. We comply with the court's order. And lordship, another writ petition subsequent.
No, he was not a senior assistant. He has come here for.
No, he was not senior assistant. He was copyist only.
He was a copyist.
Not senior assistant, but he was subsequently promoted to the senior assistant 13 July 2016 due to vacancy arises. Some, my lord, senior assistant.
Which page you are reading? Which page you are reading?
Page, my lord, page 32 in my petition, my lord, the original petition, Annex 7. Order, my lord, 13/7/2016.
No, something is wrong.
In pursuant to the Honorable High Court order, pursuant to the my lord, first writ petition,
Page 34, madam, that is a amended. Page
34.
34.
34.
In pursuant to Honorable Court High Court order 18/8/2015 passed in writ petition 137/2009, the first writ petition, the so and so Talukdar versus so and so approved accord of so and so dated 11/3/2016. Since Satyavan Talukdar revenue copyist of Koilan Revenue Cycle is hereby promoted to the vacant post of senior assistant of Koilan Revenue Cycle. This is the order, first order, my lord, he was promoted to the post of senior assistant. The order comes to come into force with effect from the date of his joining in the post. So this order has been promoted. Thereafter, his second writ petition, my lord, lordship, kindly see next page 194/2017. This writ petition, my lord, order dated 11/12/2018.
Page 38.
38, huh?
37, 38.
Yes, may I read paragraph 3, my lord? No, it was different petition.
Amended from there.
Amended from the Swain. No, may I read it, my lord? Paragraph 3.
Just a moment.
Oh, yes. Next, 194. 194. Running.
Which page?
Page 90, running page 94, my lord. Amended petition. Repetition number 194.
Page 37.
2017. Yes, my lord. Order dated 11/12/2018. Paragraph 2, lordship, kindly see. In this petition, the petitioner has claimed for a
Just a moment. Which page you are saying?
my page, this order dated, my lord, 11/12/2018 in petition number 194/2017, page 95. Amended petition.
Yes.
Yes. What's the paragraph 2? In this petition, the petitioner has claimed for a antedating promotion to the post of senior assistant, which was given from the date of his joining the post of senior assistant as per the order of 13 July 2016. Learned counsel for the petitioner submits that The effective date should have been and dated in terms of the order dated 1/37/2009. This is first order. Dispose of on 18/8/2015. Quote in the appropriate repetition, I am quoting this ballot order. Paragraph 21, this one, my lord. Viewed the above context, denial of any promotional avenue of the petitioner since he is anti to service as copied in the late 1980s is clearly unreasonable and wholly justified. In such circumstances, court is of the view that the respondent should immediately take up the case of the petitioner for promotion to the post of copies come LDA under 9190 rules, if necessary, by antedating such promotion, if necessary, my lord, such promotion from the date where the petitioner become eligible for promotion and subject to availability of vacancy of the higher cadre of copies come LDA. So there was no vacancy at that moment, my lord. Once his exercise is complete, petitioner would come within the ambit of 1916. Then he'll come with the next rules, 1967 rules. Otherwise, he is not come. Like rank rules in lower rank of LDA, and then would be entitled to a consideration for further promotion to the higher cadre of UDA, subject to course to fulfillment of eligibility criteria. The learned counsel for the petitioner submitted the petitioner was eligible for promotion, so and so, so and so. Paragraph 6, Lordship Policy.
The
Learned counsel.
senior assistant is in the rank of LDA.
Grade, no, it is a grade T, more senior most post, my lord.
UDA.
Yes,
UDA. Okay.
UDA. He was, my lord, as per copies rule 1991, 2 cadre only. Copies come LDA and copies. Then copies come LDA. Thereafter, he will be a UDA, that means senior assistant, my lord. So in this paragraph 6, Lordship kindly see, learned counsel for the state, however, submits the promotion cannot be given unless there is vacancy available. We have admitted there. And it has been submitted that the petitioner seems to have been given promotion on the basis of vacancy arising of 13/9/2015 upon retirement of Abdul Aziz, senior assistant working the Kaya Revenue Cycle. However, learned counsel for the state submits that if vacancies were available earlier, the government can consider his case for promotion. That last second repetition, we have admitted that there is no vacancies, but we have stated it. The court is of the view that under normal circumstances, retrospective promotion cannot be given unless it is a case of deliberate denial of promotion in spite of the existence of vacancies. There will be no vacancies, no denial. Thus, that's why, my lord, in the event of non-availability of vacancy, the question of unfair denial of the promotion cannot arise. We second repetition, we have stated that there is no vacancies. Accordingly, in fact, the circumstances of the cases, this court is of the view that the present petition can be disposed of with a direction to the writ petitioner to submit a detailed representation claiming promotion to the post of senior assistant from an earlier date, and which shall be considered by the authorities subject to availability of a vacancy on such an earlier date. This was the order. This order has been passed, Lordship Kali 2018, and he was given promotion 2016. That's why this order cannot be otherwise. It is complied with already earlier. He was given promotion to the post of senior assistant without having the LDM, or he got the UDA. That he is a sufficient, he is a lucky person, so he got it. Now he is saying that for 2005, when one post was getting at senior assistant was retired. So from that, how he can be without promoting him to the LDA? That at that moment he was not eligible. Post was also not there. The LDA come typist, and he was not also eligible. Otherwise eligible, but the post was not available. This is the case, my lord. So last writ petition order that has been complied with. That's why court has passed it last paragraph, my lord. This order on 13/3/2019 has already passed.
Okay.
Order dated Lordship kindly see 13/3/19. The
Okay.
last page of the this order.
Okay, I'll consider and frame the last, what do you call, last part of the order. I'll just correct. I'll release it today.
Yes.
In the chambers. You can get the order by tomorrow.
This part.
80% already dictated, only operating portion.
No, only last paragraph is
That
there.
is for
Much of it.
Lordship requires rules, my lord. I can provide you, Lordship, my lord.
Which one?
The 91 rules.
The copies rules by the draft rules.
Oh, acha.
67 rules and 91 rules, both are there. Obliged, my lord.
Wait, please, Lord.
Yes.
It's a review, my lord. Against order dated 29th of January 2021. Passed in a revision petition, my lord. By that revision order, my lord, the agreement for sale was rescinded. And the petitioner in the revision petition was directed to refund the sale consideration. That was the order, my lord.
Yes.
May I just indicate the facts of the case, just 2 minutes, my lord. Initially, my lord, this review petition as plaintiff is included suit for specific performance of an agreement for sale. And the first instance court, my lord, he rejected my prayer, but decreed that this sale consideration be refunded to me. So I preferred an appeal. Appeal was allowed. And a decree was passed, my lord, directing me to deposit this balance consideration within 1 month. And in default of this judgment debtor to execute the sale deed, then to deposit in the court. That is the order, my lord. So thereafter, we filed an execution petition, my lord. After 11 months of that appellate court judgment, my lord. And there, my lord, they filed an application under section 41. Sorry, 47. Stating that we failed to deposit this balance sale consideration within the stipulated period. And that was converted into an application under section 28 of the Specific Relief Act. And it was remanded back to the first court, my lord, the trial court, to take it part as a part of the original suit and decide it. Then, my lord, he passed an order rejecting their objection. And that was put to challenge by in this revision petition, my lord. That is put to challenge. Now, my ground of challenge, my lord, in this review is the first is, my lord, is threefold. First is, my lord, that this order, this revision is without jurisdiction. This order is appellable. My contention is that, my lord, that the settled law that in a suit for specific performance, even after a judgment is pronounced, the trial court, my lord, he continues to have jurisdiction over that suit. It was considered to be a preliminary decree. Now here, this order was passed on section 28(1). And that will merge with that decree, my lord. Any order that is passed there, because under 21, the original court has the jurisdiction, my lord, to resign the contract and set aside the decree. So that will be a decree. That will march, there can't be any two decrees. So any order passed there, in my lord, it will merge with that decree. And therefore, perhaps an appeal lies against that, not a revision. Under 115. They have invoked 115, my lord, 115. That is my first contention, my lord. Secondly, that order under revision, my lord,
is one without jurisdiction for the simple reason, my lord, it is barred by limitation. It is time barred. Because under 137 Limitation Act, my lord, limitation is 3 years. There are judgment to support that, my lord. To file an application under section 28 of the Specific Relief Act. Here, my lord, appellate decree was passed on 30/9/2011. And direction was to deposit it within 1 month. 30/9/2011. So we have to deposit it between before 30/10/2011. So their right accrues on 1/11/2011 to present an application under section 28 of the Specific Relief Act. And admittedly, they filed it in 2016.
Which date?
Date, my lord. Date is Monday. No, file for auto. 22 April 2016. 22nd April 2016. Much beyond this three years, my lord. So it's a time barred application, my lord. And no order could have been passed to him. Or in support of limitation period, my lord, I'm relying on a judgment, Andhra Pradesh High Court judgment, my lord. Document kindly see para 9.
No, because if that be the case, then this review has to be rejected. You'll have to test it in appeal, because you see, I must find out the error apparent in the order.
Error. Yes. Yes.
That is the first requirement. So when the revision was filed, did you take this did you raise these objections?
Limitation part, no, my. But my submission would be this objection of limitation perhaps can be raised at any time in view of section 3 of the Limitation Act.
By filing a review application.
Yes.
It must be error apparent on the face of record.
My lord. My lord. If the court has no jurisdiction, my lord, jurisdiction goes to the root of the matter.
No, jurisdiction you are saying of the executing court.
That is the order under revision. Order is passed on that petition, my lord, which is a time-barred petition.
This having not been raised at that point of time, the review, it will be very hard to accept that contention.
My lord,
It will be order which will be incorrect on merit.
my lord, I will satisfy your lordship. I have little difficulty today only is that I'm newly engaged. I'm appearing for the first time. This file has been handed over today morning only. My lord, may I just pray for just accommodation of a week, my lord, not more than that, so that I can satisfy all these queries.
Okay, both sides are duly presented. Adjourned for a week as paid for by law and counsel for the petitioner.
Can it be after 7, my lord? I'll be out of station from 30 to 4th.
You said 1 week.
Yes, my lord. Date be fixed so that,
Give a date.
after for any date, man, seventh if possible, seventh. Eighth, yes, yes. March it like.
On a hearing day, my lord, if possible, because earlier occasion, the other side has taken on the name of.
No, you
compromise.
see, hearing days, since I am managing my roster,
My lord,
I'm fixing some matters which which are there for hearing.
yes.
I can't group this Tuesdays and Thursdays with miscellaneous matters so that effective hearing I can't take up them. Item 10.
May I beg your lordship? Lordship, this IA is for correction of typographical error, lordship.
Yes.
As in the order dated 1/3/2023, lordship, first by the honorable court, lordship, in the para 5 and 6, lordship, the word written interim pre-arrest bail, lordship, whereas that was the final order, lordship.
Oh, acha. Item 5 and 6,
Yes.
para 5 and 6.
Para 5
Okay,
and 6.
Right. Your name?
R. Shaha, lordship,
R.
Shaha.
Saha, counsel for the Miss Saha, counsel for the petitioner, applicant, as well as Mr. Bankim Sharma and the PP for the state. Next para. This interlocutory application is for correction of the typographical error which is crept in the order dated 1/3/2023, passed in AB 6/9 of 2023. Full stop. Although the said order dated 1/3/2023 was a final order of bail, comma, due to inadvertence in para 5 and 6 of the said order. The words in sorry, make it in para 5 due to inadvertence, the word inverted commas pre-dash arrest. And in paragraph 6, the word inverted commas, interim pre-arrest has been wrongly inserted. Stop. Next, according to this, the typing error which is kept in the order dated 1/3/2023 in AB 6/9 of 2023 stands corrected. Stop. Yeah, by deleting this additional words which are script in the order. Next, for the recast, para 5 and 6 shall now read as follows. Here is to this is final order. Final order previous. The next para, this order shall be read together with order dated so and so, passed in the 6/9 of 2023.
My name, my lord, Social People Wildlife.
Acha, SC Wildlife, not ABP.
Much.
Item number 11 for hearing.
Yes.
I'll quickly recap what I had submitted on 18th of August.
You were last interpreting section 126 and 135.
That's right. That's right.
Then you were referring to that Southco case.
Yes,
Then West Bengal State Electricity Board.
yes.
You referred
These
to
two cases I have
Sitharaman's.
already placed.
Huh?
I have already placed these two.
Yes, that's why I'm recapitulating what you have last
Yes,
submitted.
yes, yes.
Then you were referring to the assessment of the PDCL is governed by 8/5/2007 code.
I'm sorry, I didn't hear.
You are saying that the assessment by the APTCL
Huh.
was governed by the code of 8/5/2007.
Supply code?
And that it was, and the assessment base was contrary to 135(1)(a).
Yes. Now. So
And you also stated that the for theft, there cannot be a best judgment assessment.
Yes. And there are two judgment which I referred on best judgment assessment. One is Safiullah of this court, Division Bench 1959. The Lordship has noted that.
Safiullah,
Yes. And then second was
Commissioner of
Yusuf-
Sales Tax.
Yes. And another is Yusuf Ali.
That is Commissioner of Sales Tax versus HM Yusuf
Yes,
Ali.
Yes, these two cases on what is best judgment assessment. More or less, best judgment assessment is more or less based on the discretion, taking into consideration. Because if your lordship remembers, section 144 of the Income Tax Act defines best judgment assessment. But of course, your lordship knows any definition in any act is for the purpose of that act. And if the definition is not there, then your lordships rely on the dictionary meaning. Now, best judgment assessment, the meaning is, my lord, what is best according to your discretion. That will be best judgment assessment. You consider the evidence, but don't rely fully on those evidence because those are not conclusive. If it is conclusive, then it's a different thing. If it is not conclusive, then you bring something and then you make a best judgment assessment. Because why best judgment assessment? Because there is no loss in case of unauthorized use of electricity. There is no abstraction. So the major difference between the two, unauthorized use of electricity and theft of electricity is there has to be an abstraction or preference of electricity in case of theft of electricity. Something is being done and a loss is being caused. But here it is unauthorized use. Suppose as per the agreement with the licensee, if I'm supposed to draw only say 6 kilowatt, and instead of 6 kilowatt, I'm using 8 kilowatt. So this is unauthorized. This is unauthorized. And my lord, I had shown while referring to Orion Metal case, where explanation was read as section 126. Now, 126, if your lordship will see, can you see 126? Electricity Act.
Electricity.
Otherwise, it is mentioned, it is there in the compilation that I have given.
The rules act. It rules Electricity Act.
It will be in the compilation.
Yes.
Page 1, Electricity Act. Section 26. 126. Now, the first say, on an inspection of any place or premises or after inspection of the equipments, gadgets, machines, devices found connected or used
or after inspection of record maintained by any person, the assessing officer comes to a conclusion that such person is indulging in unauthorized use of electricity, he shall provisionally assess to the best of his judgment the electricity charges payable by such person or any other person benefited by such use. Now, if your lordship will see explanation. Now, the explanation is attached to section 126. It is not to any subsection. Now, the assessment says, this is important, for the purpose of this section. So explanation is only for the purpose of 126. For this section, B, unauthorized use of electricity means usage of electricity by any artificial means or by means not authorized by the concerned person or authority or licensee or through a tempered meter. Now, the problem arose while interpreting through tempered meter, because similar expression your lordship will find in section 135. Kindly go to page 4, my lord, of file compilation. Page 4. Because similar expression is used, and those expressions are, my lord, in D. Uses electricity through a tempered meter. Lordship got it.
Yes.
D is at page 4. Now, if it is read only in exclusion to the other, so the opening sentence of 135, then anybody can say a similar expression. So 127 and 135 are same. But this has to be read, and I'll read it like this. Theft of electricity. Whoever dishonestly uses electricity through a tempered meter. Now, meaning of dishonestly is defined under section 24 of the Indian Penal Code. If your lordship may have Indian Penal Code. Section 24 of Indian Penal Code, IPC.
This you had referred, in the last occasion you had referred to.
Yes, I refer. I'm just trying to.
Uh-huh.
Dishonesty, if your lordship will see. Whoever does anything with intention of causing wrongful gain to one person or wrongful loss to another person is said to do things on dishonestly. So once I dishonestly use a tempered meter, that means my intention is to cause harm to the licensee and benefit to me. That is how theft comes in. But no such expression is there in 126. That is merely, it says through a tempered meter. Usage of electricity through tempered meter. It only says that. And I will place in the reply, I will place one judgment, which is of Delhi High Court. And the judgment was given by the Justice Sanjay Kishan Kaul, as he was then. Now he is the Supreme Court. And it was then, there was another case where this was relied by the division bench, presided over by Justice Sikri. All these judges went to ultimately Supreme Court. And they made a difference. They said there is difference between the what dishonestly uses the meter for the purpose of 126 and 135, because there is a dishonest abstraction under 135. So that is the difference. And that has not been, my lord, there, my lord, his lordship, with all due respect, the error occurred because of this. Now, similar, my lord, I will refer on this point only two more judgments, then I'll go to the merit of the case. The two judgments that I will refer is Shiv Alloys by single judge. The order was upheld, judgment and order was upheld by the division bench, and I will place those two decisions. T-Valois versus APDCL and others, 148. It's at page 148 of the compilation.
Page.
Page 148.
Yes.
Now, my lord, before I take your lordships to the relevant paragraphs of the judgment. My lord, this was a case of theft of electricity. And the argument was on behalf of the petitioner that there is only one provision for assessment, that is 126. There is no other provision for assessment. Therefore, under section, if a theft has occurred, taken place, the assessment will have to be made under 126. The further argument was, but appeal will not lie. So this was self-contradictory argument which was placed in this judgment. I'm placing it because of the single division bench order, the division bench judgment where I appeared before the division bench. And I tried to explain, but I'll tell before when I go to the. Now kindly see at page 151. 151.
The timing is very good. When you said that statement, Mr. Kejriwal is not there.
Yes. No, I will need him because your lordship that day, when I was referring to the inspection report, that 2 wires came out. So the mustache came out. It was his because he has saved it. I wanted to tell that. He has gone. Now, he knows it. I have pointed out. And this T-Valois has come back again. I'm doing it. Your lordship will see what page 151. Paragraph 4.
Yes.
Dr. So-and-so submits, as per third proviso to section 135(1)(a) of Electricity Act 2003, the assessed amount of electric charges for theft-related case has to be assessed in accordance with the provision of the Act. So this is the case of, this is what the case they had made. Now I'll come on that. Accordingly, my lord, under section, in paragraph 14, the court also said yes, it has to be, because that is the only provision. Paragraph 40 at page 161. 161. Paragraph 14. The assessment of electricity charges contemplated under the third proviso to subsection 1A of section 135 must be in terms of the Act 2003. That is during inspection, inasmuch as it is only during an investigation, detection of unauthorized use of electricity would be noticed. It is in inverted comma, in unauthorized use. So the said assessment must be in accordance with 126. And that was the point was not disputed, rather placed by the Council for Civil Law. Because the assessment, the said assessment must be according to section 126.
But this is contrary to what you are arguing.
Yes, that's why I'm referring, because there is a judgment against me. That's the reason I'm referring this.
Oh, okay, okay.
My lord, your lordship, no, I don't.
No. I did not understand the context.
Yeah, that's right.
Huh.
In that context, I'm saying there are two judgments which are against me, and I'm placing those judgments. Because the assessment before lodging the complaint against the theft of electricity, but after disconnection of power supply or to the consumer under 135 of the Act 2003. I'm reading again, kindly see below. So the said assessment must be according to section 126 of the Act. Why? The reason is given because the assessment is before lodging complaint. Now this is bizarre. In my humble submission, my lord will kindly see 135, third proviso at page 4. At page 4, my lord. One 135, one capital A, that must be at page 5, my lord. Page 5. Not sure. Now,
I was just thinking aloud that if I don't accept your statement, that is bad. If I accept the statement, then also it becomes bad.
That's a predicament you'll always be, because there will be judgment. But all that I want is the authentic judgment is not there according to me. Well, I have been arguing, but all that is mission stage, and then all are pending at that stage. Now, kindly see, my lord, what my lord, the learned honorable judge had said. I was reading is the assessment must be according to 126 because the assessment is before lodging complaint. Now, kindly see, is it possible? 135, 1 capital A at page 5. First, I will place 2. Second proviso, provided further that such officer of the licensee or the supplier, as the case may be, shall lodge a complaint in writing relating to commission of such offense in police station having jurisdiction within 24 hours from the time of disconnection. At disconnection, immediately they do. And thereafter, my lord, they make an assessment. And then we file objection and they make final assessment. That is the procedure. I mean, that's what they are following illegally. So see, the honorable judge writes, because the assessment is before lodging of the complaint, this I don't find anywhere. And so far as third proviso, I will take your lordship through that. So here, my lord, the counsel appearing for the petitioners agrees that there is no other provision. Now, is it so? That's a question that I ask myself. Now, my lord, once more, if your lordship will remain at page 5. At 5. Third proviso, which will be the bone of contention. Third proviso. Provided also that licensee or supplier, as the case may be, on deposit of the payment of assessed amount or the electric charges in accordance with the provision of this act shall without prejudice to the obligations to lodge complaint as referred to in subsection second proviso of this clause, restore the supply of electricity within 48 hours. So within 24 hours of the disconnection, they will have to lodge a report, and within 48 hours, if the payment is made, they will restore it. Now, what it says, my lord, payment of the assessed amount or electric charges. Now, my lord, I asked a question to myself. Where is the power of the licensee to restore power supply to the consumer, which was disconnected following theft of electricity? The power is given under third proviso. Power is not under 126. Power is under third proviso. And it says on payment of the assessed amount or electric charge. So with assessed amount, electric charge, it can be restored. So the power is already there under 135(1)(a). The only question is how the electric charges will be assessed, or on what basis the electric charges will be realized for restoring the electricity. That is the question. Now, is there any provision, that a question that I asked myself, is there any provision which provides that? Then I found that section 154(5) explanation at least provides how the assessment in case of theft of electricity shall be made. If your lordship will kindly turn to page 8 of the compilation. Section 154.
Yes.
Now, 154(5) is determination of civil liability, and civil liability has been given in explanation to this section. Now, explanation is below 6, but it is explanation to section 154. For purpose of this section, civil liability means loss or damage incurred by the board or licensee or concerned person, as the case may be, due to commission of an offense referred to under section 135. So the
Yes.
So, finally, the basis for determination of the electric charges or loss, the assessment is based on loss sustained by the licensee due to commission of the theft. On the other hand, on the basis of quantum of theft. So the assessment has to be on the basis of quantum, not on best judgment assessment. And this is, my lord, this I can substantiate by taking your lordship through 135, section 135. 135 at page 4. (135) below. Whoever dishonestly, I'll not read it because you have read it already. Does any, I will say only, does any of the, or by employing any of the method used under A to E, does anything dishonestly to abstract I'll read this, so as to abstract. So abstraction is sine qua non. Or consume or use electricity shall be punishable with imprisonment for a term which may extend to 3 years with fine or with both. This is important. This will show that it will be, even the punishment is based on quantum of electricity stolen. Provided that in a case where load abstracted, consumed or used, attempted abstraction or attempted consumption or attempted use does not exceed 10 kilowatt. The fine imposed on the first conviction shall not be less than 3 times of the financial gain on account of such theft of electricity. And in the event of second or subsequent conviction, the fine imposed shall not be less than 6 times the financial gain on account of such theft. Then number 2, if it exceeds 10 kilowatt, then the punishment will be severe as provided under subclause 2 of the proviso. Now, my lord, if the final assessment, which will be made by the civil court, by the special court, is based on quantum of electricity stolen, for the interim purpose, can it be on the basis of best judgment assessment? In my submission, no. Because there is no question of any discretion here. In case of unauthorized use, there is no loss, but yes, there is unauthorized use. So you can make best judgment assessment, but not in case of theft of electricity. And that is the reason, if your lordship can kindly turn now to page 16 of the, placed it already, but I'll just in the context that I'm submitting, page 16. It's because of this that the central government made an order, my lord. It's known as the Electricity Removal of Difficulties Order 2000. And in this, those things are there. I'll skip that. And I'll come to 2. Inclusion of measure to control theft in electricity supply code. The electricity supply code as specified by the State Commission under section 50 of the Act shall also include the following, namely method of assessment of electricity charges payable in case of theft of electricity pending adjudication by the appropriate court. So this is an interim measure. Therefore, my lord, they have to provide that in case of theft, even the interim compensation will be based on the quantum of electricity which has been stolen. If they cannot find accurately, at least some, because that is the job of the special court to determine civil liability under 154 and 150 under 154(5) and 154(6). That is the job of. But they cannot change the basis. The basis is quantum. And if your lordship, you see, I have annexed the supply code, because we are here governed by the old supply code, my lord. And the old supply code, very, my lord, at page 11, your lordship will see page 11. This is 11. Electricity Supply Code and Related Matters Regulation 2004, First Amendment 2007. This is what we are. This will apply to us, my lord. My lord can kindly turn to page 14. page 14.
Last time when it was, when you argued the matter,
My lord.
since it was in the mine, I made an inquiry, but I was informed that I was informed that there's no record of any case where this assessment has been done, actually done by the civil court. By the,
Why, I'll come to that. I can straightway answer. My lord, Justice Chief then, the then Chief Justice Adarsh Goyal, he was presiding over the case. I was sitting there. So he asked me about the state of affair of the criminal cases here, because he says that in all cases we find that there is nothing. The trial is not being conducted properly. I said reason lies with the judiciary only, because anything, anybody arrested, a remand report will be submitted and the magistrate will blindly sign. I said the very purpose of Article 22 and 167 is defeated. The magistrate is supposed to apply his mind to see if there are evidence on the basis of which this person can be arrested in the first place. And if this becomes routine, it will become routine. So here also, it has become a routine. Your Lordship has seen how the in Mr. Kejriwal's case, in Shiv Alloys, how the submission is made. Yes, it can be. The only provision for assessment is 126. 126 is for unauthorized use of electricity, where there is no obstruction. So here, my lord, your Lordship has seen, I've taken matter extensively. I have referred to Orient. But Orient says it has obliterated the difference between 135 and 136. There is no difference, because all case of theft of electricity will fall under unauthorized use.
and there are judgments of Supreme Court which says that
Yes.
that the High Court should not find fault with the order.
No, but
And then-
what I would not have normally placed this. But because it is in, my lord, contradiction with the judgment of the three judges bench.
No, you get it.
That's the reason I have placed. Because three judges bench doesn't say this. Three judges bench very clearly says that these are two different things. In fact, it says that 126 and 127 forms a code in itself, where 135 is covered by 130, theft is covered by 135. So if your Lordship, my lord, today your Lordship is confronted with a judgment consisted of three judges bench and two judges bench. Your Lordship will follow three judges bench. As in case of Assam, the other day also I said, roller and flour mill case. Srinivasan trader obliterated the difference between fee and the tax. I said it's all same. Even a little quid pro quo is there, it's okay. No 2/3 is required. The division bench, my lord, I'll place that judgment in paragraph 61, if I remember correctly. The division bench, my lord, headed by the Dean Chief Justice Chalmishar and Ravitna Rai, says this Srinivasan trader is in teeth of Keval Krishna. Therefore, they did not agree with that. So I will say the same situation your Lordship is facing here, where there is a three judges bench and two judges bench. And if it can be reconciled, yes. And on the lighter side, if your Lordship is aware or not, I don't know. There was an occasion where there was conflict between two judges bench and three judges bench in the Supreme Court. A two judges division bench presided over by Justice O. Chidappa Reddy laid down a law that if after finishing the appeal and the mercy petition, if a person is not hanged, executed within 2 years, then his death sentence will be commuted. Now, in the same year, there was another bench of three judges. I think it was, yes, same year. That was headed by Justice, I will call Senior Chandrachud now. That was in 83. Then we overruled this decision. This doesn't lay the correct law. In 1985, Similar matter again comes before a division bench presided over by Justice Ochinappa Reddy, and he was furious after seeing, and he passed the order. And these are reported cases. I'll place it some other day, I can show. He says, how can 3 judges bench overrule us? Because you're also division bench, we are also division bench. How can you overrule? Then the matter was ultimately settled by Constitution Bench in 1989. I have all those 3 decisions. And these are very interesting aspects of the matter. So here, Sitaram is by 3 judges. And the citation is there. I had given this. I'll place it. In reply, I'll place it. Now, my lord, your lordship, at page 14, I will the page 14, the last clause, 5.8.4.4. Unmetered use of electricity or theft of electricity. When a consumer indulges in theft of electricity, the officer authorized in this behalf by the government of Assam may, without prejudice to its other rights, will assess quantum of electricity loss on the basis of assessed consumption of detected category as per table so and connected load for the case so, etc. Therefore, and this must have been included after 2005 order, which I have just placed. So therefore, this has got absolutely nothing to do with 126. The assessment for the purpose of restoration of electricity or power to the premises of consumer after detection of theft does not in any way connected with 126. Now in this case, so therefore, I would submit that the decision, so far as the decision of Shiv Alloy single bench is concerned, that of course is now merged with the division bench. So I'll place division bench first. And otherwise also that will be a judgment in the facts of that case where it is admitted that 135 will be assessment under for theft of electricity will be made under 126. That is not the case here. Your lordship is dealing with a different case. But same case, my lord, the challenge, it was challenged before the division bench where I was engaged. And the judgment that was passed by the Honorable Division Bench, my lord will get at page. इसको बताया करो यार. $176, my lord. At page 176. One paragraph and your lordship will understand why I'm placing this judgment. Now, in this case, my lord, when I was engaged for this, I could not dispute or make out another case than what was made before the single judge, namely 126 will apply. Now, the only question was that even if 126 applies, this is a case where no jurisdiction, there was no jurisdiction for making assessment. Because there, why not, the assessing officer on the facts which was reflected in the inspection report must come to a finding that there is a theft of electricity. And only he will get jurisdiction to make assessment for restoration of line in case of theft of electricity. So I said here there was jurisdictional fact was totally lacking, and therefore the assessment could not have been made. And since I'm challenging the jurisdiction, 3 decisions I wanted to place, my lord. First was over the Whirlpool case, my lord. Whirlpool, your lordship, I did not cite the judgment. Whirlpool, your lordship, no, they have given exception. One of the exception is where jurisdiction of the authority is challenged, and I cannot be relegated to that position. So that is what I had challenged. There was no scope for 22 to 126 and 135. This was already admitted by us in the civil rights case. So when I submitted, your lordship will see the judgment which was passed on that, page 182. 182. This is, my lord, continuation of paragraph 6, but those 6 are my argument, which have been noted. Page 182, your lordship will see the finding. Lordship got me. So-and-so learned senior counsel for the appellant has also argued upon aspect of jurisdiction of the assessing authority on the ground that assessing officer was not having relevant materials such as inspection cum observation report and therefore any action by him in absence of this report would mean the action is without jurisdiction. All that I wanted to, I cannot improve on what is recorded. But all that, it covers almost. Although I said that unless there is jurisdictional fact or jurisdictional fact is sine qua non for exercise of jurisdiction. If that is lacking, then he could not have made any assessment. That was fine. This is how it is written. Now the second, next paragraph. We have gone through 126 of Electricity Act and find it does not speak of inspection cum observation report. So no inspection report is required according to this judgment. So the assessment will be made in abstract. Assessment cannot be made in abstract. Assessment will have to be made on some facts.
On some basis.
Yes, and 126, your lordship very clearly says facts disclosed. What is the inspection report? It contains facts which constitute either theft or unauthorized use of electricity, because the assessment cannot be made in abstract. And 126, my lord, his lordship says we have gone through, we don't find. The word starts in 126, page 4, 126 of the compilation. Page 1, sorry. The first page itself says, on an inspection of any place, premises, and after inspection of equipment, so and so, the assessing officer comes to a conclusion that such person is indulging in unauthorized use of it. So he has to satisfy that there is a case of unauthorized use of electricity, and that will be from the facts recorded in the inspection report. And they recorded as inspection cum observation report, they write something. So this judgment, according to me, is against 126 itself. Therefore, this cannot be cited by the other side saying, no division bench has upheld that their appeal lies. My purpose is that. Therefore, we are in, then the further, my lord, line, this is absolutely perfect. Therefore, we are in agreement with the learned single judge that there was no jurisdictional error as argued on behalf of the appellant. As if this point was raised before the argued and single judge has given some findings on it. My lord, may I read it again?
No.
Now, single judge's order at page 172, your lordship will say, what single judge has said is that there is not a whisper in our petition. We have not taken the point of jurisdiction. He said he did not decide the jurisdiction. I'll show your lordship will come to page 172 of the single judge's order. This is at page paragraph 26, 172. Last line, if my lord will see. From the submission of the learned counsel for the petitioner and on perusal of the averment made in the writ petition, I do not find any averment showing that there was jurisdictional error while passing final order against provisional assessment made by the assessing officer. So there is no averment in the writ petition. This is what he said, Supreme Court. Single judge. If there is any apparent jurisdictional error, there is no point in sending the petitioner to the appellate forum, in as much as that would be a mere wastage of time. That's correct. But here, the single judge said that we did not take the point in the writ petition. Therefore, he did not go into it. And division bench says he rightly decided that there was no jurisdictional error at page 182. Therefore, madam, these two judgments are not on the point. Do not discuss the points that I'm referring before your lordship. So this will not come in the way of your lordship deciding the matter. Now, my lord, I will proceed to merit of the matter. And now I'll come to the merit.
If I accept your argument, then I'm thinking of my order as matting. I would have to say the Supreme Court was incorrect in interpreting it. The division bench was incorrect in interpreting it.
No, your lordship will only say this is in teeth of the three
No,
judges.
that's okay. But
That's the only thing. Otherwise, your lordship will say that, yes, he has correctly said section 126, 6B. Can you lordship say that? I'm asking you, lord, if that be. Because sometimes something has to be stated. Because I will also be referring to that roller and flour mill judgment. Your lordship may mention that. Quote that, paragraph 61, where, and not only that, there is a judgment, I remember, that judgment is 2010 by our former Chief Justice B. Suhas Reddy, sitting with someone I don't remember. He had said, my lord, that a bench consisting of two judges bench should not say that three judges bench is for incuria. The lordship has seen that of the Supreme Court. What happened subsequently? Justice Nariman, sitting with another judge, my lord, said two constitution bench judgment in Kolhapur cane sugar, and there is another that I don't remember, upon incurium, because they did not consider section 6A of the General Causes Act.
that judgment on that day you cited Justice Chagla was not that judgment.
Yes, it is that. But that paragraph, I told, the paragraph is very long. I'll bring it next time, because today also I'll not be able to finish. I'll bring that Chagla judgment.
Where he says that two constitutional bench of the Supreme Court was incorrect in interpreting a
No,
particular provision.
that Chagla doesn't say. What Chagla said is, the question, because I told there also that that judgment is best judgment according to me on the obiter. And Justice Chagla said that when a question arises, but it is not required to be answered because the case is capable of being decided on some other point, and that point is left. And then there is a comment by the court, then that is obiter. But he says a case where the question doesn't arise at all, then that is not even an obiter. And he says the case that has been cited before him on interpretation of Sea and Custom Act, there was one penal provision. He said that case when the Supreme Court was considering it, the question did not arise, but they have given interpretation, and he says with due respect, they have not applied their mind. I'll bring that judgment. In that context, they say, Division Bench of Bombay High Court, presided over by the then Chief Justice Chagla.
No, that I'm having.
Your
But
Lordship,
I did not find that.
I'll just.
Just give me one moment. Nineteen 55 Bombay 113.
113. One, that's Ishwar Das.
113. That is the one you cited.
Yes.
I have that. Please, okay, don't trouble yourself. Reading in mobile is very inconvenient.
Right. So now I'll go in the merit of the case, and along with the merit, if I'm able to establish before your lordship, if I am able to establish, my lord, that no case of theft of electricity was present in this case or made out in this case by accepting whatever is written. In that case, there will be total lack of jurisdiction and the assessment order will be bad because of lack of jurisdiction. On that, so the jurisdiction point is not getting over. It will continue with the merit too. Now I'll place my lord. Your lordship, that day I had shown the inspection report at page 30. At page 30. At page 30. Now, what is most important is what did they find when they came to inspect the meter?
This is you are arguing the point that it was without jurisdiction.
Yes. If the jurisdictional facts are lacking, then also there cannot be any assessment. No power will come. So the jurisdiction point will also continue with this. Now, my lord, first I'll show you, lordship. At page 30, your lordship will not find this is not filled. Old seal, my lord, serial number 5, your lordship will see at page 30. Both sides, old seal particulars and new seal particulars, both are not filled. But your lordship will see the Xerox copy, the next page. Next page. In Xerox copy also, what was the stage of old? They are not written there. Seal particulars, nothing is there. But something they have mentioned in the general observation that I will take your lordship. But on the right hand side, your lordship will see, I'm showing the number of seals which are apparent from their own document. And I have counted, my lord, On the right hand side, serial number 5, new seal particulars. 1, they have given the number. I had given a passing reference, my lord, while beginning.
Last time you made a reference, yes.
Yeah, I just gave a passing reference because I said it will be repetition when I go to the merit. So I just gave a passing reference.
Okay, okay.
So now if your lordship will come to page 30, capital A, the next page of 30. It's a Xerox copy and it's in their handwriting. Serial number 5, seal particular. Now here they are supposed to give what they found. It is blank. Nothing is there. On the right hand side, if your lordship will see, I have counted and I found that there are 10 seals. At least 10 seals. My learned friend says 11. Anyway. Yes. 1. City secondary as 2. So lordship will see they have written 1, 2, 3, and 4. This is clear, my lord. Then after 4, 5, 6, then city secondary 7, 8, then optical port 10, 9, and others 1, 10. So total 10 seals. So 10 seals are there on the meter, my lord. And what they have found now I will place, my lord, general remark on observation. At page 30. As per so-and-so targeting report of GC2 visited at site, the existing metering system is physically checked. The meter cover seals, top and right seals, are found to be broken. I will pause here and submit. Only 2 seals they found, according to this, broken. Top two seals. There are 10 seals, according to their own report. And I will also show what are the seals which are intact. It is also observed that there are some yellow color wire coming out from top of the meter cover. CMRI is taken for computer analysis. It is observed that B phase CTPT has been interchanged at the metering end, which is rectified. Well, Lord, if it was a manipulation or we were causing theft of electricity by interchanging these B phase CTPT of B phase, we were interchanging. Immediately, why should they reconnect? But kindly check this mark it, my lord. CMRI is taken from computer. It is observed that B phase CT and PT has been interchanged at the metering end, which is rectified. The connection of secondary side CTPT set also checked and found okay. So secondary, they have found okay. Existing meter is taken into custody for further analysis. A new lab tested meter is installed and replaced, and the old meter is resealed with TC seals as recorded above. Now they did not seize the meter, because if they seize the meter, they will obtain my signature on that. There will be a seizure memo. But they did not. So what they found is that meter cover top seals on the right side, top and right side found to be broken. Then they said some yellow color wire coming out from top of the meter. CTPT has been interchanged. Then connection of secondary CTPT found okay. CMRI is taken for computer analysis and existing meter is replaced. So basically, my lord, three allegations. Basically, three allegations. Meter cover seal, top and right side. Yellow color wires are coming out. B phase of CTPT has been interchanged. So these are the three events which they have found in the inspection report. There is nowhere it is mentioned that there was theft of electricity or we find prima facie evidence of theft of electricity. Nowhere it is mentioned, my lord.
But this meter has been taken out for computer analysis.
Yes. Now, my lord, if it was, they should have sent it to lab for testing. And they have accredited lab.
No, but they have done it. CMRI is taken for computer analysis.
I will show, my lord. There's no escape for me. I will show what is there of CMRI. There is not an iota of evidence. If it's evidence is there, I will stop arguing, my lord. There is no iota of evidence. I will show CMRI what they are saying about that. And every case, this is a, my lord, a common, I mean, a regulated sort of answer or a general answer. CMRI is taken for computer analysis. It has to be sent to the lab. And because of that, my lord, if your lordship for a second take this, you have not that. Apply code. 2006 regulation, my lord. Yeah, you have not brought it. You have brought this or not? 2006. Your lordship will not have this book.
No, this was last time produced by Mr. Barwa.
He should have brought, but anyway.
This
I'll just give it. I'll just give it to your lordship.
violation of that 2006.
I have read it. Yes. Your lordship will see 10. Regulation 10 first. Operation, testing and maintenance of meters. Operation, testing and maintenance of all types of meters shall be carried out by generating company or the licensee as the case may be. And then 17, my lord, will kindly come to. 17. The distribution licenses shall put in place a system of quality assurance and testing of meters with approval of the appropriate commission. The licenses shall set up appropriate number of accredited testing laboratories or utilize the services of other accrediting testing laboratories. The licenses shall take immediate action to get the accreditation to their existing meter testing laboratory from NABL, if not already done. So they are supposed to have their own lab. What was the difficulty in sending the matter for testing? And CMRI analysis, I can say, they put it in the computer. And computer will show meter cover open. They have produced here, since your lordship had asked, I'll give you. This is at their AO, and it's page 179. It starts, goes backward. It is off. Your lordship has gone to paragraph 70, page 79 of the paper book.
Yes.
They have written annexure 4 continued, but there is only one annexure 4. There is no continuity here, I take on this page, at page 75. Then they start from page 79, my lord. I have typed it out. I'm given a copy to you. This I can place with your lordship, the type 1. Your lordship will see, they say that lot of meter cover opening events were found in between 10th and 12th of April 2013. So 10th, the meter cover opening is at 1:25 a.m. Then the next opening is after 38 hours at 3:39:45 p.m. After that, it was opened again. It was found detected open on 3:41:20, 1 minute 35 seconds thereafter. Then fourth opening, your lordship will see after 1 hour 44 minutes. Then fifth opening after 19 hour 39 minutes for 10 seconds. After 10 seconds, again sixth opening, and then your lordship will go on saying 10 seconds, 5 seconds. And a person who has to temper will not do it repeatedly. On the 12th itself, on the 12/4 itself, 16 times. So this is something else. This has nothing to do with theft of electricity or tempering of the meter. And that is all, my lord, in one case, what they say, and this is their standard defense. And these are, first of all, they will say, there are disputed questions. Then they will say, these are technical matters, the court should not. At least you will have to tell the thief that this is how you have committed the theft. You will not say this is a technical matter, so only it is between, it is up to us. The court will not go into it. They have labeled allegation on us that we have committed theft of electricity. They must show from evidence that we have done it. Beating around the bush will not do. I will develop it once I, my lord, proceed with the argument. Since your lordship asked, I said I'll just take this first. Now, without, my lord, on this basis of inspection report only, an assessment of 33 lakhs was made, provisional assessment, and that your lordship will find at page 31. Page 31. Page 31.
Yes.
Page 31, I'm reading it. This compensation bill is being served on you, which has been assessed on the basis of clause 5.8.3 and 5.8.4 of electricity supply. Evidence revealed that you were directly or indirectly involved in the act of malpractice. Now, my lord, earlier it was in the supply code, it was malpractice, even for the purpose of 126 or 135. And if your lordship will just see, I will have mentioned that this will be important. Kindly come to page 13, my lord. 12 first, 12. 5.8.3.1. Page 12.
Yes.
Malpractice. Malpractice, contravention of any provision of Electricity Act 2003, Indian Electricity Rules 1956, or any other law or rule governing the supply or use of electricity. Regulating order shall be treated as malpractice, and the consumer indulging in any such malpractice shall be liable under law, rule, order, etc. Now, if your lordship will turn to next page, what will constitute theft of electricity is given under G and I. Rest are, my lord, related to unauthorized use. G says theft of electricity as defined under section 135(1) of the Electricity Act 2003. And I says interfering and tampering with the meter and metering system as detailed under 135(1) and section 138 of the Electricity Act 2003. Others are all unauthorized use of electricity. So I was placing page 31, my lord. So according to 31, I was assessed under 5.8.3 and 5.8.4. Both these clauses, because they appear to be totally confused. 5.8.3, your lordship will find at page 12 of the compilation. Well, yes. So 5.8.3 is malpractice. It's as vague as it can be. And 4 is, my lord, at page 13, method of assessment of electric charge payable in case of theft pending adjudication by the appropriate court. Now, here also, my lord, your lordship will kindly see at point 4, where a consumer is found to be indulging in malpractice with regard to use of electricity and use of device committed for theft of electricity, the authorized officer under section 126 may, without prejudice to any other action that may be taken against the consumer, ask him to pay compensation which shall be assessed as stated herein below. Now, herein below, I have already said it will be decided on quantum of electricity as in 5.8.4.4. Then, my lord, the bill your lordship will see at page 32, my lord. At page 32. Page 32. This is of 33 lakhs, 19,548. And here, surprisingly, my lord, the provision that has been mentioned is 5.8.4.2 and 0.3. Can you see the provision? Both these your lordship will find at page 14. Now, 5.8 and 4.2 is resale of electricity. It is nobody's case that I'm tapping it and selling it, the electricity to someone else. At page 14, both these provisions are there. And 5.8.4.3 is interference with the metering system. So both are different provisions which has been given here. Now, the petitioner was perturbed. What happened? What I have done? So he sends a letter under RTI. Please, can you tell us what I have done? That letter, my lord, will get at page 34, Annexure C. Annexure C. And what we wanted is given in 35. Basically, my lord, instead of reading all this, I will just say, my lord, we asked to furnish analysis report of CMRI taken on 12/2/2014, because they said that CMRI is downloaded for computer analysis. So we said, give us that. Then we say whether any laboratory test was conducted in the said meter. If yes, furnish the report. Then third we wanted is analysis, if any, conducted on the meter apart from laboratory tests. So these are the query that we have posed by our RTI application. And the reply was given, my lord, by a letter dated 18/3, which your lord 2014, which your lordship will find at page 38. Page 38. The lordship got plot 18/3. This is their letter. They have given reply. With reference to the subject, I am enclosing photo copies of the reply of AGN, TNC division so and so for CMRI analysis report and lab test. Then for your information, against information sought by letter dated 7/3. And this letter was enclosed. And this letter is very important. And this will show what they have found. The first thing, my lord, they say, contents of the letter 13/3, that CT, they say vector diagram shows that CT of B phase has been interchanged with PT of B phase. Evident from vector diagram, they say. But your lordship will remember, they immediately rectified it. They say in their inspection report, it was immediately rectified. So we say, why did you rectify it? You should have called somebody to say that, what is the effect of it? Number one. Number two, can any consumer go to the transformer and change it without ensuring that the power supply will not be there for certain hours? This also we are. Then it also says, my lord, lots of cover open even recorded in the meter from 12/4/2013 to 10/4/2013. This is in reverse order, they say. I have just placed it 10/4/2013 to 12/2/2013. Then, my lord, the very important thing which they said for us is no laboratory test has been conducted. So they have not conducted any laboratory test. I'm surprised, my lord, when they are alleging theft with by virtue of tempering the meter. Why it was not sent to the lab to find out? They did not say. They said no lab test was. But reason they are giving, my lord, no laboratory test has been conducted as we tested the meter on site. At the time of inspection, the percentage of error found within allowable limit. So that means there was no defect with the meter. There was no tempering, because if there is tempering, it will not show correct reading. Because they themselves said that percentage of error was 0.
So that may have been differently. When a percentage of error is found within the allowable limit.
Yes. That means meter is.
That means on that time when they tested,
yes,
the meter was okay.
No, they tested on the spot.
It's okay.
Yes.
But it is given a reading of the present.
Yes.
So it is
My lord,
no error.
Can it be that I have tempered the meter, and when they came, I rectified it? So that
That's
the
what they are
percentage of,
saying.
no, because there is a statutory presumption. Rule 57 of the Indian Electricity Rules 1956 clearly provides that if on testing the meter shows 0, that percentage of error is within limit, then meter will be deemed to be correct. There is a deeming provision. We have dealt a lot of deeming provision in that marketing case. I have it is there in the, I have annexed the, given the 56 rules, 56 rules in the compilation. My lord, your lordship will kindly come to page 10 of the compilation. That only relevant, of course, you have given. Any meter or maximum demand indicator or other apparatus placed on the consumer premises in accordance with section 26 shall be of appropriate capacity and shall be deemed to be correct if its limits of errors are within limits specified in the relevant Indian standard specification where no such specification exists. The limit of error do not exceed 3% above or below absolute accuracy at all loads in excess of 1/10 of the full load or up to full load. So when the meter, you have found that meter was correct, when you tested and the meter was correct, that means there was no tempering of the meter. But once the meter is tempered, then there is no way to remove that tempering because these are smart meter, it records everything. And we have asked pointed questions that CMRI, you say cover open unit. Does it indicate tempering in our next? They did not reply. They did not reply to that. So your lordship will have seen the rules and these 56 rules below applies by virtue of section 185 2C because unless the rule is made under 53, though the regulation is made on regulation 2006 is made, but it is not made under section 53, it is made under different provisions. So that provision, rule 57 still applies. I don't think they will also dispute that. Now, thereafter, my lord, we submitted yet another RTI reply, which my lord will get on 29/4/2014, which my lord will get at page 50 of the paper book. (29)(4), your lordship will get at page 50. This is an RTI application. And what we wanted is given at page 51, wherein we demanded to know, my lord, 4 things. The first thing we asked was the exact effect of interchanging CT of B phase with GT of B phase. What is the exact effect? Second, we said, is it possible for a consumer to interchange CT and BT of B phase? This is because, my lord, if your lordship has seen where the transformer is installed, nobody is permitted. And if it is on the roadside, it is fenced. There are iron posts and it is fenced so that nobody goes near. He'll be burned. So unless I have pakka information that there will be no, there will be load shedding from so and so, to so and so, nobody will go there. He'll get electrocuted in saving 33 lakhs. He will die. So we asked that question. Then we also asked, did APDCL sustain any loss? In this, my lord, page 51, these questions have been put. Then we said whether cover open event reveals any tempering of the meter. Now, they did not give any reply. They kept quiet. Because if they give reply, I mean, there's nothing for them to reply, so they did not reply.
No, but there's still a doubt.
Yes.
If there are two yellow wires which are coming out of the
Yes,
of this and
top of the meter.
no, prior to that, you see, there's a Rajasthan High Court, Rajasthan State Electricity Board case, where the Supreme Court has interpreted that the CTPT would include the transformer as well as the metering
No,
system,
entire metering system.
entire
No-
metering system.
No
huh.
dispute, no dispute.
So
Not
therefore,
Yes.
the tampering may be anywhere, in the city, it can be anywhere. But the point is that when in the meter, two wires are coming out,
Yes.
they can be manipulated to show an error. And it
Now
will-
that's a presumption. What I'm saying is, these are smart meters and these are welded with ultrasonic welding. It cannot, nobody can open it. Once it is open, it destroys. There's an ombudsman finding on it, that once you open the meter, you lose all the evidence. Now, if suppose, my lord, assuming for a second, because what happens, I asked my learned friend, he is always there in electricity matters. So I asked, he says, they bring police. The atmosphere is such, they make person right. In one of the recent cases, he was there and he has stopped. He said, we will not give him right. And because they were not allowing him to write what they wanted, they just wanted the consumer to sign. So he put his foot down. So assuming, my lord, that two wires were coming out, I'm asking a question to myself, was it not their duty to send it when they have the lab? It's not that they don't have, or they have to send outside. Send it to the lab. They will open the meter. They will see where it is connected, how it was connected, and whether it interferes with correct and accurate measuring of the electricity consumed or the energy consumed. Because under 135, that is signed for non. 135, because these provisions one has to read and read. The 135, your lordship will see at page 4. At page 4, whoever dishonestly, A is theft directly, Katya. Let it. B, I'll read. Whoever dishonestly tempers a meter, installs or uses a temper meter, current reversing transformer, loop connector, or any other device or method which interferes with accurate or proper registration, calibration, metering of electric current, or otherwise results in the manner whereby electricity is stolen or wasted. So these two wires are there. It may create a doubt if it is there that there must be something, otherwise why should it come out from the top, as your lordship said. Your lordship can see the reason now. So, but that you have the lab, send it, let them find out from where, what is the source, and whether it can interfere with the correct and accurate recording of the energy consumed. If they say yes, it is, then what case we can have before your lordship. But whatever is here can be speculative. But at least, I'm not saying your doubt, but at least prima facie it must be established, because the Newport says it must be established prima facie. So earlier also the same principle will apply. When you are alleging theft, you have to show that, look, these are the grounds on which we feel that, yes, you have indulged in theft of electricity. There is nothing, my lord, except what they are saying. That will not be. Because once, my lord, the lab report is there, we cannot dispute it. And my lord, even here before your lordship,
Because here in this RTA reply, page 53,
Yes.
they are disclosing, they have given a photograph. Annexure 1 of the, this wire coming out from the top of the meter. Page 53.
Just and this is your lordship is referring to letter dated 30th 4th.
34, there is the RTA reply.
This is actually final assessment bill.
Oh, acha.
This final assessment bill.
Final assessment.
What they
Here-
have done is the preliminary assessment which they made for the purpose of restoring, they say that that is final because we did not file any
No, here
reply.
they say that the 9-4, some yellow color wire coming out of the top of the
Yes.
meter.
That
And
is,
you have been provided with a photograph of that.
we'll check it out.
It's mentioned there.
We'll check it out. Interfering with the, there is no objection filed. They were found meter zinc cover broken and some yellow cover top of the list. Madam, annexure 1, that is photo. This is, they are referring to not photocopy. Photo enclosed, that is photocopy.
No, photo of the meter.
Photo
In photo of the meter where two wires are coming out.
Yeah, photo enclosed here, annexure 1, it has been interchanged. My lord, it is not only that, was broken and also observed that there were some yellow color wire coming out from top of the meter cover and B phase CTBT has been interchanged. Photo enclosed, annexure 1. So this is, I will check it up. What is this photo? I'll check it up because today though I'll not be able to finish complete it. We'll check it up because in another case which is coming before Chief Justice tomorrow, there also they said same thing, it's enclosed photo. Luckily in that case, the petitioner wrote back, where is the photo? You have not. Till date they have not produced, Chief Justice is asking them to produce. Tomorrow that case will be there. So I'll check it up next date. So,
State category. 31st. Fixing it next.
First, I'll be going out. I'm actually leaving on 30th, 7th, if your lordship can, or on the reopening day, if it is inconvenient, your lordship.
Yes.
First, 7th. I don't even here, before your lordship, the affidavit in opposition they have filed is also based on speculation. They are speculating. I'll place below their affidavit in opposition. They say it is impliedly inferred. There's no question of implied inference. There has to be some evidence to show that there has been a theft of electricity and not inference from the, when meter is there, they are alleging tempering of the meter. You have taken away the meter, you have the lab, get it tested. But they say, no, since the meter, the percentage of error was correct, we did not send it. So then you don't serve us any copy. Well, why should you make assessment if that is the case?
The submissions of Mr. D.K. Mishra, Senior Counsel, assisted by record your name, Mr.
Yes,
D.
yes,
Prasad,
he will make
counsel
it.
for the petitioner. remains inconclusive. Mr. A. Barwa, standing counsel for the APDCL is present. List as part of matter on 7/9/2023. And is agreed to by both sides. Yes, 7/9 is part of matter.
Lord, I just want to point out one thing. In fact, when I was not keeping well, I had filed a written argument, both on alternative remedy as well as on merit. Well, my learned friend has checked. There is some typographical error at page 110. It is written wrongly. In place of not, it is also. Will lordship permit us to correct it?
Your written submission.
Yes. Okay. My written submission is at page 105. 105.
Correct the copy of Mr. Barwa also.
We have solved it because it was filed. One word in place of also, it will be not. Your
Your book-
lordship, we will correct both the copies.
Ah. This is his book. The other matters will be rolled over, Mr. Tiwari. Mr. Mishra, please don't go. I expect some fireworks here.
No, not, the other two cases will not, could it be on 19th or 29th of August? 29th of this month.
Sorry.
It's Tuesday, 29th.
Yes.
Lordship, there is an
No, the
interim lordship.
fireworks is no longer there. You may leave.
I thought it required to be extinguished.
Before my lord, there are never fireworks. If at all, the lord, they come, my lord's calm and tranquil disposition, my lord, douses the fire.
No. Good day.
Lordship, there's an
29th.
interim lordship that
Yes,
may
that-
kindly be continued. Lordship.
Hmm?
There's an interim order passed earlier, Lordship, that may be continued.
The positive time matter could not be taken up today. List was also interim order passed to list as extended to the next date of the listing. We record your presence also,
Yes, my lord. Item 12 and 13.
Yes, Lordship.
your
12
name,
and 13.
B. Chetri, Lordship. MS B. Chetri, Lordship.
B. Chetri,
Yes,
for the petitioner, Mr. P.K. Tiwari, senior counsel, assisted by Mr.
AR Gogoi.
E.R. Gugoi for the respondent, and Mr. You are also there.
I am in item number 12. What are you comment?
E.K. CGC for the government present. Okay.
Obliged.
What extended?